number 38.
38.
My lords, the arguing counsel is currently not in station. If I may seek for a short adjournment. my lords.
2017 idu.
My lords, one short adjournment, arguing counsel is traveling, my lords, currently not in station.
Aditya, kodaboda? Call after 2 weeks, finally at the request of
Much obliged.
Serial number
Serial number 13, Lordship.
30.
30. I'm praying for short adjournment. Kindly have it next week, Lord.
Next week. 2 weeks at the request of
serial number 23, please.
23.
Please. Would it be next week any date, not 30th or 31st?
ಏನಂತದಿದೆ ಇದ್ರಲ್ಲಿ ಅಷ್ಟಫ್ ಇದೆಯಾ?
Entry model is there.
ಸರಿ, call after
Serial number 41, ma'am.
Could be in the first week of
model
February.
to continue. Okay.
Serial number 41, ma'am. Serial number 41.
48,
1, my lords.
2019.
We have informed the opposite counsel also.
You are informed.
Yes.
2 weeks at the request of
Serial number 36, my lord.
36.
Yes, my lord.
ಏನಿದು?
Lord, you need some 2 weeks time to prepare and argue this matter, my lord.
2015 matter.
Yes, my lord. Yes, my lord. So, no matter suddenly it has come, my lord. Needs time to prepare the issues that, my lord, regarding 35 2AB deduction, whether DSIR is the prescribed authority having power to do it, or the assessing officer has power to do it, my lord. It requires some time to prepare and argue.
2 weeks. at
2
the
weeks.
request. Adjourned by 2 weeks
Much obliged.
37.
at the request of finally. 37,
Yes, sir.
2016 matter.
It's a Supreme Court remand matter. Transfer pricing.
ರಿಮ್ಯಾಂಡ್ ಯಾವಾಗ ಆಗಿದೆ? ಬಹಳ ಹಿಂದಾಗಿದೆ. ಟೈಮ್ ಬೌಂಡ್
Transfer
ಇರುತ್ತೆ.
pricing. matter. Transfer pricing.
ಟ್ರಾನ್ಸ್ಫರ್ ಪ್ರೈಸಿಂಗ್
Yes.
ಅದ ಇದು.
Yes, sir.
ಓಕೆ. 37 and 37 and 39 to be called together ಮಾಡ್ಬೋದಾ? ಬೇರೆ ಬೇರೆ ಇದೆ. 37 ಎರಡನ್ನು ನೋಡಮ್ಮ. After 6 weeks. Come on. Since similar questions are being debated before this court in a partnered matter. Okay.
I'll file the submissions within the next week, my lords. 10 days, my lords. It's almost ready.
2017.
Yes, my lords. We'll file the submission. my lords.
ಅಲ್ಲ ಸಬ್ಮಿಷನ್ ಆಯ್ತು. ಸಬ್ಮಿಷನ್ ಮಾಡ್ಬೇಕಲ್ಲ, ಆರ್ಗ್ಯೂ ಮಾಡ್ಬೇಕಲ್ಲ.
Yes, ma'am. On Feb 10th, it may be posted, my lords.
Sorry. Call on 10th
February 10th, ma'am. By that time, I'll file the submissions and serve it up.
ಮಾಡ್ಬೋದಾ? At the request of. Final.
Needful done today.
Needful done.
Yes, ma'am.
ನೋಡಮ್ಮ. Needful done, registered to verify. Stated to have been done. Verify.
My lords, in
Tanmay.
this matter, the client is exploring the possibility of settling the matter under Vivad Se Vishwas scheme.
2 weeks at the request of counsel for the appellant on the ground that amicable settlement efforts are being made. Efforts are being made for amicable settlement. Okay. Under Vivad scheme, enta scheme?
Vivad se
Vishwas.
Vivad se Vishwas.
Vivad se Vishwas scheme. Vivad se Vishwas scheme. Okay. Next.
I am for the petitioner, my lord.
ಏನು ಎಲ್ಲಿದ್ದಾರೆ? ಜೀವನ್ ನಿರಲ್ಗಿ ಪಾಸ್ ಅವ್ರು ಮಾಡಿ ಬರ್ಲಿ.
Memo, my lord, for bringing the present jurisdictional officer on record, my lord. Memo for substitution.
ಅಪ್ಲಿಕೇಶನ್ ಹಾಕ್ಬೇಕಲ್ವಾ? ಯಾರು ಹಾಕ್ಯಾರಿದ್ರು?
I am for the petitioner.
ಮೆಮೋ ಹಿಂಗೆ ಸಬ್ಸ್ಟಿಟ್ಯೂಷನ್ ಇದನ್ನೆಲ್ಲ ಮಾಡ್ಲಿಕ್ಕೆ ಅಪ್ಲಿಕೇಶನ್ ಬೇಕಾಗ್ತದೆ.
Officer,
Huh?
that officer present jurisdiction because now the GST scheme regime
ಅದ್ರಲ್ಲಿ
is
ಬೇರೆ
there, my lord.
ಆಗಿದ್ದಾರೆ.
ಬೇರೆ ಆಗಿದ್ದಾರೆ officer.
ಮಾಡ್ಬೋದಾ?
No.
The panel counsel, senior panel counsel appearing for the respondents has filed a memo. Next paragraph. Learned counsel for the appellant, although initially opposed the same, now in all agrees with the proposal in the memo. Off matter. agrees with the proposal in the memo. First stop. Next paragraph. In view of the above, the petitioner is directed to substitute the principal commissioner of Central GST, North Commissionerate, HMT Bhavan, Bellary Road, Bangalore, in place of Commissioner of Central Excise, Customs and Service Tax, Bangalore. A memo dalle ನೋಡಿ ಗೊತ್ತಾಗ್ತದೆ ಲಾಸ್ಟ್ ಹಿಂಗ್ ಮಾರ್ಕ್ ಮಾಡಿದ್ದೇನೆ ಎಲ್ಲ ಇಷ್ಟು ಮಾಡಿ ಕೊಟ್ಬಿಡಿ.
Maybe I'll do the with the registrar, maybe taken up after 2 weeks.
Yes, amendment to the cost table to be effected after within 2 weeks. Effected immediately, call after 2 weeks. Okay. Rajesh Shetty gara. ಏನಿದು?
This matter, I'm filing a memo.
ಹಾ
I've received instructions that back wages have been paid and I'm filing a memo with the statement that is
Not fully complied.
reflecting, my lords.
ಕೊಡಿ. ಏನದು? Well, good. What is the order?
Lords, the order is of reinstatement and certain back wages to be paid. 50% back wages to be paid.
ಗೊತ್ತಾಗಿದೆಯಾ?
Reinstatement, there appears to be no controversy.
Very well.
And back wages, I have produced now a calculation. I also have the treasury challans if
It's already, when are you going to make payment?
it is made, my lord. I have,
You have already made the payment. Chalan is also produced.
9 lakhs paid.
Huh?
Only 9 lakhs is paid.
ಮತ್ತೆ ಅದು ಮುಂದೆ ನೀವು ಚಾಲೆಂಜ್ ಮಾಡ್ಬೇಕು.
More than 15 lakhs is.
ಚಾಲೆಂಜ್ ಮಾಡ್ಬೇಕು. ಕಂಪ್ಲೈನ್ಸ್ ಇದ್ರೆ ನೋಡಿರಲ್ಲ ಇನ್ನ EMS ನಂಬುದ್ರಿ ವಾಟ್ ಅಪೆಕ್ಸ್ ಕೋರ್ಟ್ ಸೆಡ್.
Will challenge.
ಬರ್ಕೊಳ್ಳಿ.
the calculation is their gross salary deduction because 50%.
If you are aggrieved by that, you have to challenge liberty, we will give you.
Please.
But this complaint alleges violation of order entered in writ appeal number 551 of 2022. Correct?
Yes, ma'am.
Wherein
5th January.
a direction was given for reinstatement and for payment of 50% of wages, back wages. First. Earlier case complaint in CC's. First. Learned AGA appearing for the respondents has filed a memo to the effect that petitioner has been paid the back wages in a sum of rupees 9,01,457. First off, he hastens to add that since already the complainant, petitioner the complainant, since already the complainant is reinstated in service, there is substantial compliance of the writ, and therefore these proceedings be dropped. First, we agree. Next paragraph. In the above circumstances, this complaint of contempt is disposed of. This application is disposed of, preserving liberty to the complainant to take appropriate proceedings if some more amount is due in terms of order whose violation is complained of, in accordance with law. Full stop. In that connection, all contentions to both the sides are kept open. All right. No.
My lord, I may be permitted to take hand summons, my lord, along with fresh steps.
5-1, ಅಲೋ ಮಾಡಿ ಅಂದ್ರೆ ಕಾಲ್ ಮಾಡಿ ಆರ್ಡರ್ನ ಮೇನ್ ಮ್ಯಾಟರ್ ಮೇಲೆ ಮಾಡ್ಬೇಕಾಗತ್ತೆ. ಅಲ್ಲಿ ಅಪ್ಲಿಕೇಶನ್ ಫಾರ್ ರಿಕಾಲಿಂಗ್ having been allowed, met the order dated so and so is recalled and CCC is restored to the board. First, next, with consent of the party, the same is taken for hearing. ಅದ್ ಹಾಕೊಂಡು ಮುಂದಿನ ಬರೀಬೇಕು. Yes.
My lord, I may be permitted to take fresh steps, my lord, along with hand summons. 3 times we have already sent.
Fresh steps along with the hand summons within 1 week. Yes. Narasimharaju. ಇದು ರಿವೈವಲ್ ಮಾಡೋಣ. Application,
ಇದರಲ್ಲಿ there is an endorsement.
ಕೊಡಿ. ಅಲ್ಲ ಈಗ ರಿವೈವಲ್ ಮಾಡಿಕೊಂಡು then we'll consider the main matter itself.
Very well.
ಅಲ್ವಾ?
May I submit?
Same type.
May I submit?
Endorsement ಏನಂತ ಇದೆ?
After application, Lord.
The way the apex court said we should
Yes.
not wait ಅಂತಲ್ಲ ಅದೇ ಇದೆ. ಗೊತ್ತಾಯ್ತು.
Well,
Endorsement
Lord, once, Lord, it was deferred.
ಹಾ.
Subsequently, we challenged that order before the apex court. Apex
Ah.
court said, Lord, let the court can go on with the contempt proceedings. But subsequently, Lordship has given sufficient opportunity.
What has happened is, my lord, after the order in the writ petition, application was considered and endorsement is issued, my lords, on 2/6/2023. There is also, in the endorsement, there is also RPAD receipt of having dispatched it to the complainant. Unfortunately, my lords, neither my predecessor, neither my colleague, nor the complainant has brought this on record before any court, my lords.
Correct.
Well,
ಅದಕ್ಕೆ
that-
ಸಲುವಾಗಿ you should take appropriate proceeding. You had filed appeal. Appeal also came to be dismissed.
Please, my lords.
But then order, a decree may be wrong. But the wrong decree is no less a decree.
It is, there is no
ಅಲ್ವಾ?
doubt.
ಮತ್ತೆ ಅದ್ರ ಮೇಲೆ ನೀವೇನಾರ ಮಾಡ್ಕೋಬೇಕು. Otherwise, as long as decree stands, he is entitled to be the owner of the property by virtue of adverse possession ಅಂತ ಹೋಲ್ಡ್ ಮಾಡಿದ್ದಾರೆ. ನಿಮ್ಮ appeal against the decree failed. Now, because of the
Because it
proviso.
was time part, I was not permitted.
ಮತ್ತೆ?
That there is, the district government pleader has issued an opinion, there is a challenge now contemplated. I am not on that point, my lord.
ಹಾ.
The judgment of this honorable court, my lord, directs.
ರಿಕಾಲ್ ಮಾಡಿಬೋಣ. ಆಮೇಲೆ ನಿಮ್ದು
Recall, my lord.
ಇದನ್ನ ಹಾಕೊಳ್ಳಿ.
And may I submit?
ಅಲೋ ಮಾಡೋದು ಬೇಡವಾ?
Lordship subsequently, after revealing the filing of the application, several orders already being passed.
Whether it is restored? No. Not restored. Examine ಮಾಡಿದೆ ನಾನು. ಅಲೋ ಮಾಡ್ಬೇಕಿತ್ತು. ಬರ್ಕೊಳ್ಳಿ. The complainant has filed a application in IA number 1 of 2023 seeking revival of the subject complaint which was otherwise disposed of by another bench, wide order dated 11/6/2024.
13/10/2023, madam. 13/10/2023.
13/10/2023. First, learned counsel for the complainant submits that rightly or wrongly there is a decree of declaration of title by virtue of adverse possession and appeal of the government against the same has ended in vain. First, that being the position, even the alleged wrong decree would continue to be operative as if it is one of the most impeccable ones. Impeccable one. ಅಷ್ಟೇ. Impeccable. First, learned AGA opposes the application contending that the subject decree has been obtained by suppressing certain facts and by misleading the court, and therefore person who alleges a complaint as to non-compliance of the decree should not be shown indulgence. First, next, having heard the learned counsel for the parties and having perused the application supported by the affidavit, we are of the considered view that a decree obtained rightly or wrongly has legal efficacy in view of decision of the apex court in AR 1992 SC 111 para 567 till it is set aside in due course. First, that being the position, the application is favored and the order dated 13/10/2023 is recorded. First off, as a consequence, the complaint is restored as it was before. First off, your
Lordships may kindly see page 53 of the contempt minutes.
ಅಲ್ಲ ಇದಕ್ಕೊಂದು objection ಹಾಕ್ಬೇಕಾಗತ್ತೆ ನೀವೀಗ.
ಹಾಕ್ತೀನಿ. I just
ಯಾಕೆಂದ್ರೆ rightly or wrongly, it is now RA has attained finality. But you had taken all those grounds. Even then RA is dismissed.
my lords.
Is it not? Maybe because they did not condone the delay. I read the papers yesterday. Therefore, there is an order. ಆ ಪ್ರಕಾರ ನೀವು ಏನ್ ಮಾಡ್ಬೇಕು ಮಾಡ್ಬೇಕು. What action you have taken against the officials who, according to you, conspired in his favor?
Cause notice has been issued, my lord. A reply has been obtained.
ಅದನ್ನ ಹಾಕಿ.
ಅದೆಲ್ಲ
2 weeks to file objections to the main matter. Yes.
Date may be kindly.
Barely,
because
2 weeks.
2000.
You,
decree. No.
who, what is your standing?
No, my stand is not
That you have got the decree.
decree.
Ah, that's
Positive direction was issued by the learned single judge.
Your case itself is by adverse possession, you have become the
But
owner of the government
No,
property.
No, my submission. They contested the matter.
Correct.
Subsequently, it was decreed. Appeal was filed.
Correct.
It was rejected.
It's
Supreme
that. What
Court-
is
my
you are
question-
saying?
Supreme Court said, my lord, that this honorable court
Should
go on the
proceed with
contempt proceeding.
That's where proceed.
My lordship has given sufficient opportunity.
Not-
Till today, my lord, my
Not-
submission. One date may be kindly, my lord, because
But
from 1990, I am suffering for the decree, my lord.
you
Till
are suffering for that.
No.
You have obtained the
For
land of the
no,
government.
for not
Government
getting,
should say
for
that.
not getting the revenue entries, my lord. With great respect, my lord. I am
Great respect
suffering.
ನಾವು ಹೇಳ್ತೇವೆ brother.
ಅಲ್ಲ ಒಂದು ಡೇಟ್ ಕೊಡಿ ಬಿಕಾಸ್ ಲಾಸ್ಟ್ ಕೈಂಡ್ಲಿ ಸಿಮ್ ಲಾಸ್ಟ್ ಕೈಂಡ್ಲಿ ಫಾರ್ ಮೂಮೆಂಟ್ ತಾವು ಡೇಟ್ ನೋಡಿ
Call this
ತಾವೇ
matter.
ಸಫಿಶಿಯಂಟ್ ಆಪರ್ಚುನಿಟಿ ಕೊಟ್ಟಿದ್ದೀರಾ ಆಲ್ರೆಡಿ
But
Please,
you should know how you have got the title also.
ದಟ್ ಇಸ್ ನಾಟ್
That is permissible for us to decide in contempt matters. There are such judgments. Anyway,
Lord,
now we will not say that.
ಸುಪ್ರೀಂ
Call
ಕೋರ್ಟ್
this matter on 13th of February.
ಪ್ಲೀಸ್
At the request of science.
ಪ್ಲೀಸ್
Government is valuable land. I am not saying about this. This is third or fourth matter. Where your officers do not take up the battle at all. Straightway they concede, they run away from the battlefield. What is this happening? You should tell them. Lord Krishna says, Nadainyam napalayanam, we will fight. That should be the attitude of the government. No, Nadainyam napalayanam, shall not run away. But you see, valuable property you have left, government's property. I am not saying anything about rightfulness, wrongfulness of the decree because I have the decree now. What action you have taken against the officers? If all that public property goes like this, then
1970 this is not a valuable land. Only 39 guntas. Now, my lord, some value may be increased. my lord. Because from 1969, I am in cultivation of the land. Necessary documents being produced. Decree was drawn. And appeal was also.
case
That is
adverse
the reason.
possession, no.
No.
Case adverse
Last-
possession. Not that.
No.
You want to read?
Lordship said it's, no.
I come
Lordship
after
said it's a
reading the
valuable
papers.
land.
No,
That is
not.
not
You have got
valuable land by
law-
that time.
Law in your favor, justice in their favor.
Please.
In such cases, what we should do, we know.
Please.
Let the matter be posted next day. Yes. Yes.
For 2 weeks time.
2 weeks finally for
Filing better.
filing better affidavit.
539 days delay, they have to detailedly explain. For 2 weeks time.
Third time it has come. Give some good book to the
Your
library.
Lordship, relating to royalty issue, my lord, I have to examine that whether the clauses in the agreement is required to is
But third time,
third time,
ಒಂದ್ ಸಾರಿ ಬಂದವರು 1000-2000 ಹೋಗ್ತದೆ ಗವರ್ಮೆಂಟ್ಗೆ.
last chance.
ಎಷ್ಟು ಹ್ಯಾಂಡ್ಸ್ ವರ್ಕ್ ಮಾಡ್ತಾವ್? ಎಷ್ಟು
Last-
ಜನ ಕಾಯ್ಬೇಕು ನಿಮ್ ಸಲುವಾಗಿ? ಮೂರ್ ಸರಿ ಇದಕ್ಕೆ.
Last
Give one good book.
Last
Otherwise,
one,
you are dismissing.
1 week, last.
One
time.
week ಕೊಡಿ. 1 week ಕೊಡ್ಬೇಕು. Otherwise, every time ಎಲ್ಲ affidavit fresh affidavit ಬೇರೆ ಇದಾಗ್ತಾ ಇದೆ courtನಲ್ಲಿ. 2 weeks finally, subject to the condition that the petitioner, the appellant revenue shall present one book of DVG, Jivana Dharma Yoga, to Advocates Association, Bangalore. Yes. ಬಡಿ ನೀವು ನೋಡಿ ಅದನ್ನ ಚೆನ್ನಾಗಿದೆ, ಒಂದು ಉತ್ಕೃಷ್ಟವಾದ ಪುಸ್ತಕ. Sangesh should be knowing that.
The needful is done, my lord.
Huh?
Needful is
done.
Also, my lords,
Register it very-
interim order may be extended, my lords.
Every government come tell us. AG requested to accept notice for respondents. Interim order to continue. Call after, call next week?
Yes, my lord.
Call next week at the request of. ಅವ್ರಿಗೆ ಕಾಪಿ ಕೊಟ್ರಿ ನೋ?
We'll give, my lord.
ಕೊಟ್ಬಿಡಿ. Interim order would continue. When, with effect from the date, the copy of the petition is heard and the same is, the acknowledgement is filed in the registry and not otherwise. Okay.
Please.
Served on the EGA. Okay.
My lords, I
Thank
appear for the petition on this matter, my lords. I request for 1 day's time, my lords. We have engaged the
1 day time.
services of.
You have any objection for giving more time? 2024 matter.
My lords,
We'll give you 10 days now. Instead, we'll put 1 0 to what you have said.
my lords, if 1 day's time is
But
given,
you-
we have engaged the services of senior counsel CV Nagesh, my lords, sir.
ಯಾರು ಬಂದ್ರು ಅಷ್ಟೇ ಇಲ್ಲ, ಎಲ್ಲರಿಗೂ ಅಷ್ಟೇ ರೆಸ್ಪೆಕ್ಟ್, ಸ್ವಲ್ಪ ಹೆಚ್ಚು ರೆಸ್ಪೆಕ್ಟ್, ಎಲ್ಲರಿಗೂ ಹೆಚ್ಚು ರೆಸ್ಪೆಕ್ಟ್
Lots.
ನಮ್ಮಲ್ಲಿ. ಯಾರೇ ಬರ್ಲಿ, don't drop names in the court hall. We are against it.
Yes, my
Yes. Call this matter
My lords,
next week.
my lords, one
at
more
the re-
submission, my lords, with respect to office objections, my lords. We have cleared everything. There's one objection pending as to the fact that Tahsildar is not impleaded. He's not a party to the suit, my lords.
Suit,
Party to the present writ, my lords. In the
Ah.
present writ,
whether he was a party in the court
no,
below?
my lords,
He
he
was
is not at all a party involved, my lords, in the
ಬಡಿ,
matter.
ತೋರಿಸಿ, ಬಡಿ. ಅಲ್ಲಿ proceedings ಅನ್ನ at whose instance ತಗೊಂಡಾರ? Land grabbing.
My lords, it was a case transferred from the magistrate, initiated based on a.
Magistrate?
Yes, my lords, it was initiated based on the charge sheet filed by the respondent police, my lords. So the Tahsildar is not involved in any way, my lords.
But very well, but we direct you to make the Tahsildar party now. Markali. Petitioner to state is there already.
Yes, my lords.
They have not served the copy on us.
Copy.
Yes, I will serve a copy, my lords. My lords, I will serve a copy. Today, my lords, serve a copy.
That is Bangalore.
ಅಂದ್ರೆ ಸ್ಟೇಟ್ ಹಂಗ್ ಮಾಡ್ಲಿಕ್ಕೆ ಬರ್ತದಾ? BBMP, what kind of cost title?
Yes, my lord.
Read cost title. How to understand this? Is it BBMP? Is it state? Is it police?
The state by Bangalore.
ಇದು Union of India represented by 143 crore people ಅಂತ ಹೇಳ್ದಂಗಿದೆ. ಹೆಂಗೆ?
My lords, I'll clarify, my lords, I'll correct it,
Petitioner
my
to
lords.
petitioner to rightly describe the respondent. First off, further, he is directed to implead jurisdictional Tahsildar as additional respondent. First off. Interim order to continue. Idiya, agela. But post after amendment of the cost title.
My lords, if a date may be fixed, my
All
lords.
right, it will come. Post immediately after amendment of the cost title. Yes,
And for the
yes.
petitioner, the translated copies are not necessary, my lord, of the subject.
Not necessary.
Please.
Counsel for the petitioner submits that the translation dispensary.
Of annexes.
ಏನಿದು ಪಾಟೀಲ್?
Lord, the petitioner is the owner of the total 8 survey numbers of Vadrahalli. Lord, in between the land of the petitioner, 30 guntas of land belongs to the burial ground of the village. Do not have approach road. Then the villagers requested the petitioner hearing
to provide a road, approach road to the burial ground.
Yes.
Accordingly, the village Gram Panchayat has passed the resolution at the request of the villagers. And 14 guntas of land belongs to the burial ground. And 1 acre land belongs to the petitioner has been exchanged. Accordingly, resolution passed and the report submitted by Tahsildar and Assistant Commissioner. Now the matter is pending before the Deputy Commissioner. Annexure, my lord, page number 20. Page 20 may kindly be seen. Page number 23 is the last paragraph.
3.
It is pending before the Deputy Commissioner for orders regarding exchange of land. In the meanwhile, my lord, the response 4 and 5 have filed complaint before the land grabbing, my lord, court, a special court for land grabbing. And the cognizance has been taken and summons has been ordered against the petitioner's hearing. The matter is pending before the Deputy Commissioner for orders for exchange of land. I have not trespassed into the land belonging to the burial ground or the government. I surrendered my 1 acre of land to the village.
For burial ground.
Please, madam. This is the resolution, Annexure B.
You gave that 34 guntas.
Please, madam. Annexure B, my lord, is the
Tell you
resolution, page number 13. For convenient to the villagers, my lord, I have surrendered my valuable property, converted land I have given.
There is a report from the DC.
1 acre, 1
The
acre.
page number 37, my lordship. Where DC themselves has filed a report stating that 37, my lordship.
That is the order I have sent.
DC has filed the report. In the said letter stated that Vadarali village of 34 guntas burial 18 guntas have been encroached by Sri G. N. Ramakrishna.
in respect of that, in fact, it is his own land, which he has
Now it
gifted
has
to the
come- railway track-
government.
Railway track has come up. my
That's all right. Now, the proceedings for exchange of land are pending. And Deputy Commissioner has to consider.
My lordship, there
Till
is
then, how can you proceed again? And he's a person who has given the land for burial.
Converted land, 1 acre of converted land I have
a
given.
matter is pending before the civil court. That special court has also directed to get the transfer, that case also before the special
It is
court. that-
different.
No, no,
Based
Deputy
on-
Commissioner ಏನ್ ಮಾಡಿದ್ದಾರೆ ಅಂತ
And the
ನೋಡ್ಕೊಂಡು
notice has to go to the
Correct.
contesting respondent.
ಬರ್ಕೊಳ್ಳಿ. Issue emergent notice, learned AGA on request accepts notice for 1 to 3. Emergent notice to 4 and 5. Interim prayer ಏನ್ ಕೇಳಿರಿ ಪಾಟಿ?
Not stay up further proceedings, my lord.
Interim order as prayed for. Till next date of hearing. All.
Yes.
Lord,
delay of 10 days, my lord.
Madam, application allowed, application in IA number 1 of 2023 supported by an affidavit seeks condonation of a short delay of 10 days. First. Explanation is plausible and delay is too short to be lethal. First. Application allowed, delay is condoned.
Transfer pricing matter.
Transfer by same questions.
Page
Appeal
number
is-
8, 1 to 3.
Appeal is admitted on the substantial questions of law, which are reproduced below. We have noted that similar questions are being debated in several matters before this court, which are already admitted. Next. Yaru? Madam, Madam,
I don't
Gowd,
know. I don't know the
Madam
benefit
Gowd.
of the papers, my lord, so I.
ಪೇಪರ್ಸು ಕೊಡಲ್ವಾ? ಯಾರಿಗೆ ಕೊಟ್ರಿ? ಏನ್ರಿ ಎಲ್ಲರೂ ನಿಮ್ಮ ಮೇಲೆ ಕಂಪ್ಲೇಂಟ್ ಹೇಳ್ತಾರೆ, ನೀವು ಯಾರು ಕೊಡುದೇ ಇಲ್ಲ.
Fellowship ಇಲ್ಲ.
ಹಂಗೆಲ್ಲ ಮಾಡ.
Fellowship, I am sharing it, my lord.
ಕೊಡಿ.
I was not aware, my lord. I am sorry, my lord.
ಸೇಮ್ ಆರ್ಡರ್ ನೋಡಮ್ಮ, 47 days. ಆಲ್ ರೈಟ್. ಅಲ್ಲಿ ಕ್ವಶನ್ಸ್ ಅದು ಅಡ್ಮಿಟ್ ಸೈನ್ಸ್. ಹಾ.
400 days delay, my lord.
400 days delay.
Transfer pricing matter.
ಆಲ್ ರೈಟ್, ಡಿಲೇ ನೋಡೋಣ ಏನಾಗಿ, ಏನ್ ಡಿಲೇ ಎಕ್ಸ್ಪ್ಲನೇಷನ್ ಏನಿದೆ ನೋಡೋಣ. ನೀವು ಅಬ್ಜೆಕ್ಷನ್ ಹಾಕಿಲ್ವಾ?
Objection ಆಗಿದೆ.
ಹಾಕಿರಾ? ಬಡಿ. ಏನು ಟೇಬಲ್ ಟು ಟೇಬಲ್ ಅದೇ ಗ್ರೌಂಡ್ ಹೆಂಗ್ ಹಂಗೆಲ್ಲ ಮಾಡಿದ್ರೆ ಸುಮ್ನೆ ನೀವು ಬೇರೆ ನಿಮ್ಮ ಮ್ಯಾಟ್ರಸ್ಸಿಗೆ ಪಾರ್ಲಿಮೆಂಟಿಗೆ ಹೇಳಿ ನೀವು ಅಮೆಂಡ್ ಮಾಡಿಕೊಳ್ಳಿ, ನಿಮ್ಗೆ ಡಿಲೇನೇ ಇಲ್ಲ ಅನ್ನೋ ರೀತಿ ಯಾವ ಬೇಕಾವಾಗ ನೀವು ಹಾಕಂಗ್ ಮಾಡ್ಕೊಂಬಿಡಿ.
This is covered in, under, little bit of time is covered under COVID also.
ಕೋವಿಡ್ ಪೀರಿಯಡ್ ಇತ್ತಾ ಅದನ್ನ ಇಟ್ಕೊಂಡು ಅದು ಮೈನಸ್ ಮಾಡಿ ಇಷ್ಟು 400 ಡೇಸ್
400.
ಅದು ಮೈನಸ್ ಮಾಡಿದೆ ಎಷ್ಟು ಒಂದ್ ಕೇಸ್ ಡಮ್ ಅನ್ಸೋಣ, ಅವಾಗ ಸರಿ ಆಗ್ತಾರೆ ನಿಮ್ ಡಿಪಾರ್ಟ್ಮೆಂಟ್ನವ್ರು.
These
What
are
case is-
all matters will now be, none of the cases will not come in. What is being filed? Because the pronouncement was in 2020.
Date of communication on, Your Worship, in our objections, here, page number 2, we have given the synopsis.
Page number 9, my lord.
ಮಾಡ್ಕೊಳ್ಳಿ. Heard on application in IA number ಎಷ್ಟದು 1 of 2024. Full stop. There is a delay of 418 days in filing the appeal. Full stop. Application is supported by affidavit. Full stop. Objections are filed by the assessee to the said application. Of my bidding. All day. First, learned counsel for the revenue. Learned panel counsel appearing for the revenue submits that the explanation offered in the application supported by the affidavit constitutes a plausible explanation and therefore the delay needs to be condoned. Full stop. He further submits that the questions framed, substantial questions of law framed in this appeal are substantially similar to those in which the hearing has been going on. First stop. Learned counsel appearing for the assessee per contra opposes the application, saying that the explanation offered does not have elements of is not plausible. Full stop. Delay is long and that cannot be as a matter of course condoned merely because the appellant is the state. First, next, having heard the learned counsel for the parties and having perused the appeal papers along with the application supported by the affidavit and also the objections filed to the said application, we are of the considered view that there is a plausible explanation for the delay proved in filing the appeal. First up, we also agree with the submission of panel counsel that the questions that are framed as substantial questions,
One question.
the question that has been framed as a substantial question of law for admission of this appeal is one of the questions being debated on the floor of this court in other connected matters in which hearing is going on. First up, the condonation of delay would not add any merits to the appeal to the prejudice of other side. First up, if delay is not condoned, the revenue would be put to a manifest injustice. First up, of course, the condonation of delay should be conditional. First up. Next one, in the above circumstances, the application, subject application having been favored, the delay is condoned, subject to the condition that the appellant shall pay 10,000 rupees to the respondent assessee by way of costs. Next.
10,000 will not.
25,000 ಆಗ್ತದೆ ಜಾಸ್ತಿ ಮಾತಾಡ್ತೀರಿ, ಯಾಕಂದ್ರೆ ಒಂದ್ ಕೇಸ್ ಅಲ್ಲ ಇದು. ದಿವಸ ನಿಮ್ ಡಿಪಾರ್ಟ್ಮೆಂಟ್ ಅವ್ರು ಆಟ ಆಡ್ತಾ ಇದಾರೆ ಕೋರ್ಟ್ ಜೊತೆ. We wanted to cost 25,000, but anyway, first bite now. The second bite will be very deep. Very, very deep. State does not stand on a different footing. State is also a litigant. He is a very big litigant, is another thing. Next.
Not maybe.
To 10,000 to the assessee within 10 days, failing which application stands automatically rejected and as a consequence appeal also. Okay. Next. Ah. Ah. Buddy. Yes, 10,000 rupees to the assessee. Bakalam. Same order. Okay.
Within
Failing
2
which-
weeks.
Huh?
2 weeks.
Within 2 weeks, failing which application stands rejected and as a consequence appeal also will be. Next. Yes.
Your Lordship, transfer pricing issues are involved, my lord. 24 days delay, my lord.
Madam,
Question number 1
Application.
and 2.
application allowed. ಸರ್ವಾಗಿದೆ ತಾನೆ?
Sarvagide,
ಆಯ್ತು. Allowed. Delay is
somebody has
controlled.
entered appearance.
Appeal is admitted on the substantial question of law as framed in the appeal memo. Which read as under. Okay. Yes.
Your Lordship, in the course of the day, I am filing better affidavit, my lord. Or officer, he is coming, my lord. I am filing the better affidavit today, my lord.
But you have 19,
18, my lord.
18. 24 days. What is that?
492 days. ma'am.
492, my lord. I am filing better.
492. Ah,
I am filing better affidavit today, my lord.
how many times time was given to you?
Your Lordship, he is coming now. He is on the way, my lord. He is just signing it. I file it.
Password.
Please.
Password. Yes,
2 days delay, my lord, notice has to go.
notice. Ah. Yes, sir.
My lord,
We'll
appeal-
pass out. ಇವ್ನು ಮುಗಿಸ್ಕೊಂಡ್ಬಿಡ್ತೀವಿ. ಅದಾದ್ಮೇಲೆ ತೊಗೊಂಡ್ರೆ. Can we pass out?
Admission ಬಂದಿದೆ.
Admission even.
ಹಾ. Last time your lordships have condoned the delays.
That's what. Sorry. But
The short question is, my lord, whether
ah,
non-issuance of notice under section 143(2),
143(2).
143(2) is
Ah.
fatal.
Ah.
My lord, the submission of the contention of the revenue is.
How various high courts in the country
I'll
have
come to
treated
that,
this.
my lord.
ಅಷ್ಟೇ question.
How the learned single judge has relied upon one judgment of the Honorable Apex Court in the case of Hotel Blue Moon,
Ah.
page number 14. That was, my lord, issued in the context of block assessment. My lord, para 4, page 14.
Yes. Assistant Commissioner of Commercial Tax versus.
Oh. So that
Of tax
judgment
versus
came to
hotel
be
bill.
rendered
Ah.
in the context of, my lord, appreciating section 158 BDBC, which
Not
deals with
143
block
too.
no, block assessment. I'll come to the procedure in which, my lord, the assessments are completed. Section 139 contemplates filing of returns.
Yes, 139.
139.
Ah,
I'll just go briefly, just the outlines. If a return is not filed under 139, section 142(1) can be issued, asking you to file returns.
142,
1,
asking him to file return.
returns.
When he has not, when he
He
does
has
not file.
If he has filed the returns under 139,
Ah,
again, the officer can issue a notice under section 143, 142(1). Again,
when he has filed.
even if he has filed under, because it got subsection,
Yes, sir.
seeking for details like accounts,
Okay.
balance sheets, etc., etc. So in case 139 is issued in two instances, one where
Where he has filed ITR, but you want to ascertain
certain
credentials.
details,
you
get
will issue
details. If he has not
Where he has
filed,
not filed, you will also ask him to file one by issuing notice.
in
That is
a
under
case,
142(1).
142(1).
Ah.
In a case where he files a return after getting a notice under 143(1), 142(1), then the officer is bound to send a notice under 143(2), seeking for details and giving an opportunity of, essentially the notices are issued seeking for details and also giving an opportunity to the assessee to represent his case. So in case where the return is filed, the contention of the
Return is filed under 139 or
139 or
142(1).
142(1) al madidunu, the returns will be treated as returns filed under 139.
That stands on the same footing.
Same footing.
In other words, one second. ನಮ್ ಕಲ್ಸ್ಬೇಕು
Please,
ಸ್ವಲ್ಪ,
please.
ನಮ್ಗೆ ಗೊತ್ತಿರಲ್ಲ, ಬೇರೆ ಫೀಲ್ಡ್ ಇಂದ ಬಂದಿರ್ತೇವೆ ನಾವು. 139 provides for filing of return. And a scrupulous
Return-
citizen will file one.
I'll just.
ನಾವ್
returns
ಹೇಳೋದು
have to
ಕೇಳಿ,
be
ನಮ್ ಸರಿ
filed.
ಇದ್ರೆ ನೀವು ಆಮೇಲೆ ಹೇಳಿ. 139 provides for filing of the return. It mandates filing of the return. And a scrupulous citizen files ITR. Then the authority is entitled to issue, if he wants, notice under 142(1), asking for details, accounts. So this is one scenario where the citizen is not scrupulous, arguably, and at that time we will issue notice under 142(1), asking him to file the return. It is like reminder, is a kind of. That return is on par with return under 139 only.
Only.
Okay. The only difference is under 142(1), where on direction of yours, he files the ITR, you are bound to issue him notice calling for the details. That's the only difference. Up to that.
Unless that return is accepted. If it is accepted, there is nothing more to be done. If it is not, if it doesn't accept. Now, my lord, here in this case, notice under 148 came to be sent for assessing the undisclosed income which has escaped
income,
assessment.
Escaped assessment.
So the section says a return filed in response to 148 will be treated as a return under 139.
Okay.
Because even if I go to another section where a search is conducted, there also a return filed consequent to the notice sent under 153C also will be treated as a return filed under 139, because the proceedings will continue from 139 only. One is regular assessment under regular assessment where return is filed under 139. One scenario is where escaped income is assessed under 148, 147, 148. Another scenario is where a search is conducted under 132. But invariably, all the returns will have to be filed, which will be
139.
treated as return filed under 139. So here in this case, a notice came to be issued under 148.
148.
48, saying that escaped income has to be
The
assessed.
escaped income ಇದೆ, you have not declared income, therefore file ITR ಅಂತ ಹೇಳಿದ್ರೆ ಅವನಿಗೆ.
I am only stating brief.
ಗೊತ್ತಾಯ್ತು.
In response to that, the SSC says, my earlier return file may be treated as the return filed in response to 148, which he is entitled to because there is no escapement. You treat my original return as the return filed under section
139.
In response to 148.
Correct. You treat my return, which I have already filed under 139, as the return filed pursuant to proceedings under 148.
148. Subsequent to that, a notice is issued under 143, 142(1)
ಏನದು?
by the assessing authority. You give some details. That is in my lord page number. I'll take my lordships to directly to page number 52 first. There he says, the last but one.
Wish to bring.
I wish to bring to your attention that I've already filed a true and complete return disclosing the facts, etc., etc.
May be
At the-
treated as a return filed in response to aforesaid.
Notice.
Correct.
Subsequently, a notice is issued under 142(1), which is in page 56. 55, 56.
55 ಏನೋ ಹೊಡೆದು ಹಾಕಿರಲ್ಲ.
ಎರಡಿದೆ. 55, ink page 55. 142(1).
ಅಲ್ಲ ಸ್ಟ್ರೈಕ್ ಆಫ್ ಮಾಡಿರಲ್ಲ ಇದನ್ನ.
ಇಲ್ಲ ಬೇಡ ಮಾಡೋದು ಬೇಡ, ಬಿಕಾಸ್ ಇಟ್ ಈಸ್.
ಅಲ್ಲ ನೀವೇ ಮಾಡಿರಿ ಅದಕ್ಕೆ. ನಾವು ಮಾಡಿಲ್ಲ, ನಾವು ಬೇರೆ ಓದ್ತೇವೆ ಪೇಪರ್ಸ್.
ಅಲ್ಲ ಅಲ್ಲಿ ಸಿ ದಿಸ್ ಒನ್ ಎ ಬಿ ಸಿ.
ಇದು ನಾಟ್ ಅಪ್ಲಿಕೇಬಲ್ ಅಂತ ಮೇಲಿಂದು
ಸಿ. Because that is to prepare a true return. My lordship, I made a submission where the returns are not filed. A ಅಲ್ಲಿ ಬರುತ್ತೆ.
ಎದಲ್ಲಿ ಬರ್ತದೆ.
ಎದಲ್ಲಿ ಬರುತ್ತೆ.
ನಾಟ್ ಫೈಲ್ಡ್ ಅನ್ನೋದು 142(1)(a.
You are required to prepare a true and correct return ಅಂತ. In that scenario. Here where the returns are filed, see, the details are in next page. Please furnish your trading account, profit, page number 56.
This will be 142(1). 142(1).
Because returns are filed. Then after that, subsequently, page number 59, 60, 61. The officer goes on sending notices, scrutiny notices, seeking details and requesting him to appear. Then subsequently, the notices, my lord, are issued till 19/2/2014.
Multiple notices.
Multiple notices issued. And whenever a notice under 148 is issued, the SSC is entitled to get the reasons recorded in writing why the notice is sent, where is the escapement prima facie, which is recorded by the assessing authority. So that he asks for asks for the reasons recorded, that is applied to him. Then the officer passes a speaking order against it. That is in 101.
101.
101. The order passed by the assessing authority.
ಇಲ್ಲಿ ಪ್ಯಾರಾ 4 ನಲ್ಲಿ ಹೇಳುವಂತ ನೋಟಿಸ್ ಯಾವುದು? ಪ್ಯಾರಾ 4 of the impugned order.
I'll come.
Which is that order?
Please,
That notice. ಅದನ್ನ ಕೊಟ್ಟಿಲ್ಲ ಅಂತ ಹೇಳ್ತಾರಲ್ಲ ಅವರು.
56. I'll come.
Page 14.
Page below.
Page 14 of the impugned. The impugned para 4.
I'll come
of
to
the
that.
impugned order.
I'm coming to that.
Yeah.
Now, my lord, these are the facts.
Yes.
So during the time of assessment, my lord, speaking about 143(2), which, my lord, I made my submissions, where the returns are filed in response to section 142(1), or, my lord, in case where there is a search, etc., etc.
But you have said, kindly read para 5. You have conceded. Once an order is made on the basis of concession, consent, where is the appealability?
You know, this one fact was not looked into.
You go before the learned judge. It amounts to virtually misleading the court if your stand is true. The courts have, even Privy Council said, where an order is made on the stand taken by the parties, admitted stand on law, rightly or wrongly, that order is made. Then generally you are stopped from filing the appeal. If you want to say that what I said is wrong, or that I never said that, but by mistake you have written like that, or deliberately you have written like that, extreme case, then you have to go before the same court ಅಂತ ಒಳ್ಳೆ ಮಾಡಿದ್ದಾರೆ 93 Supreme Court. ಅಲ್ಲಿ ಹೋಗ್ಬೇಕು.
Because the applicability
ನೀವು ಒಪ್ಕೊಂಡ್ರಿದ್ನ. ಈಗ ನಂಬ್ತೇವೆ ನಾವು. ಯು ಆರ್ ಲೈಕ್ ಲಾರ್ಡ್ ರಾಮ, ನಮ್ಮ ಗವರ್ಮೆಂಟ್. ನೀವು ಗವರ್ಮೆಂಟ್ ರಾಜ ಪ್ರತ್ಯಕ್ಷ ದೇವತಃ, ಸರ್ಕಾರ ಪ್ರತ್ಯಕ್ಷ ದೇವತಃ. ನೀವು ಹೇಳಿದ್ದು ನಂಬ್ಕೊಂಡು ನಾವು ಮಾಡೇವಪ್ಪ ಜಡ್ಜ್ಗಳು. ನಮ್ ತಪ್ಪಿದ್ರೆ ನೀವು ಹೋಗಿ ಅಲ್ಲಿ ಬರ್ಕೊಳ್ಳಿ. ಏನಾರ ಹೇಳೋದಿದ್ಯಾ?
That's what I wanted to submit, that if this matter was heard for not 2 days, it was heard. At the end of noticing this honorable court, the Supreme Court decision, we cited 3 other high courts had taken same view, my lord. My learned friend is now trying to distinguish to say 153 different assessment, alla consider madi, our high court, Madras High Court, Bombay High Court, and following Supreme Court, they have said 143(2) is mandatory if you have to reopen. Therefore, not learned counsel was then appearing, very fairly said that this seems to be covered. Even they can't go back is the service.
If you want to do there.
Liberty maybe.
Berkeley. This intra-court appeal is directed against a learned single judge's order dated 9/3/2021, whereby assessees WP number 13326 of 2014 TIT having been favored, relief has been accorded to him. First. Learned senior panel counsel appearing for the revenue vehemently argues that the learned single judge misconstrued apex court decision in Hotel Blue Moon, Nodama, para 4 nalli 2010, so and so, and therefore arrived at a wrong conclusion to the effect that notice of the kind was a sine qua non. First, he also takes us through the appeal papers, which were part of the paper book before the learned single judge. First, next paragraph. Learned senior advocate appearing for the respondent SAC resists the appeal, drawing attention of the court to the text of paragraphs 4 and 4, and submits that appeal of the kind is not maintainable since the writ petition was disposed of on the admitted position of law. First, we agree with this because the paragraphs 4 and 5 of the impugned order read as under. First, next point. In the above circumstances, appeal is dismissed, reserving liberty to the appellant revenue to explore other proceedings in accordance with law. First, in that connection, all contentions are kept off. No course. Mr. Naganand, do you have that judgment of the apex court?
Yes, Lord.
In such circumstance, they should go before the same judge and one judgment.
Oh, I'll give it, Lord. Yes,
No,
yes, Lord.
ask what I say.
In fact, they say that if there's some misstatement,
No,
you
they
must
should
go
go
and
before
file
the same
before
judge.
the same learned judge or the court
Correct.
and file an affidavit and point out to the court.
Correct.
I'll give it, Lord.
My lord, appear for the appellant in this matter.
Ah,
My lord, there is a delay of 341 days.
yes.
My lord, this delay is actually on the reason that the earlier standing counsel who was appearing in the matter, who was allotted to file this appeal, was suffering from a medical condition because of which she could not attend to her office for more than 8 months.
8 months.
So ಅದೊಂದೇ ಕಾರಣ ಅದಕ್ಕೆ.
Leave it to your lordships. They've mentioned in the affidavit saying that they've received after 1 year. So I leave it to your lordships.
Other ಬಗ್ಗೆ where have you stated about that?
Para 3, my lord, in the affidavit,
There are 3.
5 lines down. After receiving the papers from the department, I fell ill and was diagnosed with Condoria Malaysia Patelia, because of which I was not able to work and visit my office for a period more than 8 months during the year 2022 and 23, and could not comply with the office.
ಅವ್ರ ಹೆಸರು ಕೊಡಿ. ಲಾಯರ್ ಪ್ಯಾನಲ್ ಕೌನ್ಸಿಲ್ ನೋಡಮ್ಮ, ಅವ್ರು ಆ ಪೀರಿಯಡ್ ನಲ್ಲಿ ಯಾವ ಕೇಸ್ ಫೈಲ್ ಮಾಡ್ಯಾರ ನೋಡಿ. Go to registry.
ಅವ್ರದ್ದು affidavit. Vanita.
We want to assert
please.
whether what she is saying is true or not. It's very easy to assert, na? Yes, not good. ಆ ಹೆಸರು ಕೊಡಿ.
Vanita KR.
ವನಿತಾ KR.
Vanita KR.
ನೋಡು, ವನಿತಾ KR ಹೆಸರಿಗೆ ಆ ಪೀರಿಯಡ್ ನಲ್ಲಿ ಎಷ್ಟು ಕೇಸ್ ಫೈಲ್ ಆಗಿದೆ? ಯಾವ ಪೀರಿಯಡ್ ಅದು?
Between 2002 and 2003.
2002
and 2003.
2023.
22-23.
22. Sorry, 2003. My apologies. This was renominated to me, so I am.
ವೆರಿ ಇಲ್ಲ ಜಸ್ಟ್ ಅಸರ್ಟ್
Please.
ಹೇಳಿ ನಿಜ ಇದೆಯಲ್ಲ ಅದು ನೀವು ನಿಜ ಹೇಳಿದ್ರೆ ಅವ್ರು ನಿಜ ಹೇಳಿ ಗೊತ್ತಾಗಲ್ಲ ಅಟ್ಲೀಸ್ಟ್ ನೋಡೋಣ ಪ್ಲೀಸ್ ನೋಡಮ್ಮ. ಅವ್ರಿಗೆ ಅದನ್ನ ಸರ್ಟನ್ ಮಾಡ್ಕೊಂಡು ಹೇಳಿ ಕಾಲ್ ಟುಮಾರೋ ಪ್ಲೀಸ್. ಇಲ್ಲ ಮತ್ತೆ ಆ ಎನ್ಕ್ವೈರಿ ಮಾಡೋದ ಬೇಡ ಒಂದು 10,000 ರೂಪಾಯಿ ಇವ್ರಿಗೆ ಕೊಟ್ಬಿಟ್ರೆ ಮುಗಿಸ್ಬೋಣ. ಆಪ್ಷನ್ is yours. ಆ ಎನ್ಕ್ವೈರಿ ಮಾಡಿದ್ಮೇಲೆ ಮತ್ತೆ ಆಕಿ ಟೈಮ್ ಈ ಕೇಸ್ ಫೈಲ್ ಆಗಿತ್ತು ಅಂದ್ರೆ ನಾ ಬಿಡೋದು. State does not stand on a different footing. Law should be very rigorously applied to the case against state also. ಮೊದ್ಲಿತ್ತದು ಯಾವುದೋ ಒಂದು we were being taught in the law school, the legal remembrancer versus of Calcutta versus so and so, that has been reversed by the apex court, saying that all law will apply to the state unless the law otherwise says. Earlier we was law will not apply to the state.
Unless there is exception to this.
ಹಂಗಿದೆ ಮತ್ತೆ ಈಗ 10,000 ರೂಪಾಯಿ ಕೊಟ್ಬಿಟ್ರೆ ಆಗಿ ಹೋಗ್ಬಿಡ್ತು. Otherwise you run the risk. 10,000 rupees for not undertaking the exercise.
I will take instructions, my lord.
ಇಲ್ಲ ಇಲ್ಲ ಹೇಳ್ಬೇಕು ಇಲ್ಲಪ್ಪ ಇಲ್ಲ ಆರ್ಡರ್ ಮಾಡಕ್ಕೆ ಆ ಇನ್ಸ್ಟ್ರಕ್ಷನ್ ಎಲ್ಲ ಇಲ್ಲ.
ಅವ್ರದ್ದು affidavit, it was renominated to me, ಅದಕ್ಕೋಸ್ಕರ. In
Call-
fact,
call-
the
call-
advocate only has filed the affidavit.
ಕಾಲ್ ಕುಮಾರ್ ಅದು ನೋಡಿ ವೆರಿಫೈ ಮಾಡ್ಕೊಂಡು ಹೇಳ್ಬೇಕು ನಂಗೆ. Registry to the registrar judicial to verify whether ಶ್ರೀಮತಿ ಯಾರೋ ಒಂದಿದ್ದಾರೆ had filed any cases during the period between 2022 and 2023 and the case particulars as well in a discrete report.
Now she is not even in the panel also.
ನೋಡ ನೀವು ಈಗ ಆ ಗ್ರೌಂಡ್ ನೀವು ತಗೊಂಡಿರಪ್ಪ ಹೌದಾ, ಅವರು ಕೋರ್ಟ್ಗೆ ಬಂದಿಲ್ಲ ಹಿಂಗಾಗಿದೆ ಅಂತ ಯಾವ್ದೋ ಒಂದು ಮೆಡಿಕಲ್ ಏಲ್ಮೆಂಟ್ ಅನ್ನು ಯು ಹ್ಯಾವ್ ನೇಮ್ಡ್ ಆಲ್ಸೋ. ಲೆಟ್ ಅಸ್ ಹಾ 20:27. ಓಕೆ
First stress one.
yes
I pray for 10 days time to not.
you want time
Enter, please.
okay ಏನಿದು you have moved matter by
I have moved this matter. I have challenged the impugned order passed by the State Consumer Forum Lordship. The grievance is the petitioner herein is a retired Lieutenant General. He served nation for more than 40 years. And for that reason, he got the site at concessional rate. 40 into 60 site, Muda allotted the site. After the payment of the entire amount, 1,60,500 is the entire sale consideration. After the payment of the entire sale consideration, the respondent number 1, Muda, allotted they gave endorsement saying that your last installment is not within the time, hence we are cancelling your allotment for the said reason. And Lordship may kindly see I have produced all the details for payment of the installments. Within 3 installments, I have paid the entire amount. Entire sale consideration is 1,60,560. I have.
you want to file objections? Any objections you want to file or you want to comply with the order?
But as regards to that, I wanted to see the entire original file which is filed before the consumer forum. Then I'll get back.
When you want?
Next
Because
week.
he's a person who has fought for the.
That's why, my lord, I want to see the entire file. That I will make. I will come with.
You choose any date. That day we will not give adjournment. Choose a date.
30th, my lord.
All
Lord,
right. Please, this matter on.
One subdivision, statement of objection file ಮಾಡಿದ್ದಾರೆ.
ಅಲ್ಲ ಫೈಲ್ ನೋಡ್ತೇವೆ ಅಂತಾರ ಅಲ್ಲಿ ಕೆಳಗೆ ಇದರಲ್ಲಿ ಎಂಟೈರ್ ಫೈಲ್ ನೋಡ್ತೇವೆ ಅಂತ ನೋಡ್ಲಿ ಸರ್.
ಆಯ್ತು.
ನಿಮ್ಮಲ್ಲಿ ಇದೆಯಾ ಏನಾದ್ರು ಎಂಟೈರ್
ಎಲ್ಲ ಫೈಲ್ ಎಲ್ಲ ಫೈಲ್ ಡೀಟೇಲ್ಸ್
ಎಂಟೈರ್ ಇದೆಯಾ?
ಎಂಟೈರ್ ಅಂದ್ರೆ ಸ್ಟೇಟ್ ಕನ್ಸ್ಯೂಮರ್ ಇಂಪ್ಯೂಗ್ಡ್ ಆರ್ಡರ್ಸ್, ಕನ್ಸ್ಯೂಮರ್ ಕಂಪ್ಲೇಂಟ್ ದೇರ್ ನಮ್ಮ ಇದು.
ಎನಿವೆ ಲೆಟ್ ಹಿಮ್ ಲುಕ್ ಇನ್.
Please, my lord.
ನೋಡ್ಕೊಂಡ್ ಬನ್ನಿ. ಅಥವಾ ಇನ್ ದ ಮೀನ್ ವೈಲ್ ಆರ್ಡರ್ ಅಪಿಯರ್ಸ್ ಟು ಬಿ ವೆರಿ ವೆರಿ ರಾಂಗ್. Your friend is saying
29th.
something.
29th.
29,
Please.
29.
Please.
Little, even Apex Court has
Please.
said this. When defense people are involved,
Please.
they should have some special treatment because they guard the frontiers of the country. ಅವರಿಗೆಲ್ಲ ನಾವು ಹೆಚ್ಚು ರೆಸ್ಪೆಕ್ಟ್ ಕೊಡಬೇಕು. ಅದರ ಲಾ ವೈಲೇಟ್ ಮಾಡಬೇಕು ಅಂತಲ್ಲ.
I made submission, lad, only to see the file. Because the reason behind this, lad, only to contact the commissioner, is there any possibility?
Just ಅವ್ರಿಗೆ ಹೇಳಿ.
That's why
You
instead of
tell your
saying the
commissioner.
directly, lad, I said,
Because here is a
like,
person.
please,
40 years he has served
please.
in the defense.
We have to see in a
And he has
dignified
made
and
the payment.
proud manner, we have to see it, please.
And there are two judgments. You have to bring those judgments. Where Justice Anand Bairarati and another is Justice Ashok Inchigiri, they have said, even when the soldier has made the payment belatedly, still cite has to be given. A judgment tombarbeku.
Because lad, instead of, I could not undertake before this court.
Correct.
That's
Yeah.
why I make such submission.
You are entitled to.
Please.
You have conference with your
Please.
commissioner and tell him,
Please.
that the commissioner, BDA have to be little lenient to the defense people. They are in the evening of life. 40 years they have spent their life in the borders of the country. Just imagine, please. Otherwise they feel let down. Yes.
Much.
Hard.
But this is a repetition against the order.
Lord, I am for the fourth respondent. I am the auction purchaser.
I am for the respondent.
Lord, I have succeeded way back in 2020.
I am the petitioner.
I'm just saying I'm the fourth respondent.
Anyway,
Please.
I am
Alright.
the
This is a writ petition, my lord.
We will not pass any order without hearing Manu Kulkarni. Huh? Kodi. Yes.
If I may submit, my lord, in short as to what is the.
ಏನಾಗ್ತದೆ ಒಂದೊಂದ್ಸರಿ ಒಂದು ಐ ವಿಲ್ ನಾಟ್ ನೇಮ್ ದ ಜಡ್ಜ್ ಅವ್ರ ಮುಂದೆ ಐ ವಾಸ್ ಸೆಂಟ್ರಲ್ ಗವರ್ಮೆಂಟ್ ಲಾಯರ್. ಜಡ್ಜ್ ವಾಸ್ ವೆರಿ ಗ್ರೇಸ್ಫುಲ್ ಅನ್ಲೈಕ್ ಮೀ. ಐ ಲೈಕ್ ಮೈ ಬ್ರದರ್. There was a transfer order that was challenged and K. Subrao was the lawyer for petitioner. You have seen. I stood up and I wanted to make a submission that this transfer order is withdrawn. Mr. Subrao said, no, till I complete my argument, you are not supposed to say anything. I was not allowed to speak. Then matter went on up to 12 o'clock, it went on. It's very lengthy arguments, generally, the Subrao's argument, very knowledgeable also is another thing. At 12 again, I stood up. Learned judge said, Mr. Dikshit, when your turn comes, you should stand up, not now. Be seated. I sat down. 1:30 ತನಕ 2:30 ಸ್ಟಾರ್ಟ್ ಆತ್ ಮತ್ತೆ ಇಡೀ ದಿವಸ ಒಂದೇ ಮ್ಯಾಟರ್. ಲಾಸ್ಟಿಗೆ ವಾಟ್ ಡು ಯು ಸೇ, ದಿ ಟ್ರಾನ್ಸ್ಫರ್ ಆರ್ಡರ್ ಈಸ್ ವಿಡ್ರಾನ್ ಅಂತ ಹೇಳ. ಯು ಫೆಲೋ, ಯು ಶುಡ್ ಹ್ಯಾವ್ ಟೋಲ್ಡ್ ಇಟ್ ಇನ್ then I told my lord, I wanted to say this, but I was not permitted. ಅನ್ಕೊಂಡು it was very gracious, very graceful judges those days. ಅಂತವೇನೇ ಇರ್ತದೆ ಒಂದ್ಸಲ. Anyway, yes.
Lord, the order impugned is the order of the Debts Recovery Appellate Tribunal,
DRAT,
DRAT.
Chennai.
In respect of pre-deposit entitling me to prefer an appeal.
Section 17 or 18?
18. my lords. 18. There are two grounds, my lords, on which I am before your lordship. First is that there are two appeals. The Honorable Tribunal says I have to make the deposit in both the appeals.
Against the same order,
They are not against the
different orders.
different orders, but they emanate from the same debt.
Emanating from the same debt.
And therefore, the same section 13(2) notice is the basis for both the appeals.
ನಿಮ್ ಕಂಟೆನ್ಷನ್ ಏನು ಅಂದ್ರೆ, ಸಪೋಸ್ ಒಂದು 10 ಅಪೀಲ್ಸ್ ಇತ್ತು ಅಂದ್ರೆ ಸೇಮ್ ಡೆಟ್ ನಿಂದ
ಅದು
10 times ಆಗ್ತದೆ ಅಂತ ನೀವು.
Please.
That cannot be.
That
Object of prescription is that the lender or it may be same for others, it's only for the borrower.
for the borrower.
Borrower centric.
Please.
Okay. So
And
ensure that entire amount in the event you fail in the appeal, the amount should be at least reach, so much amount should reach the
Please.
pocket of the lender.
Please. That would,
How courts have interpreted this provision? How courts have answered this question?
lords, there is one decision of the Kerala High Court, there is one decision of the Madras High Court. The Madras High Court, my lords, holds in my favor. There, father and sons both file appeals in respect of the same
Very
debt.
same order or debt.
In respect of the same debt. Both of them file separate appeals. Both their appeals are rejected. Both of them file appeals. In their appeals before the DRAT, the Madras High Court says, "Now, because it's the same debt, both cannot be ordered to make the pre-deposit." But in a surface action, there are multiple stages at which an appeal can be preferred. For instance, my lords, in this case, there is a physical possession notice where actual possession may not be taken. That is under challenge. Then, my lords, the second challenge could be.
ಐದು appeal ಹಾಕಿದ್ರೆ 5 ಪಟ್ಟು ತುಂಬಕ್ಕಾಗ್ತದೆ.
Now, that would be an absurd
Stands to
construction.
absurdity ಅನ್ನೋದು ನಿಮ್ contention.
Please,
Madras judgment ಕೊಡಿ.
please. You have signed.
Yeah, so that's-
ಇಷ್ಟೇ ಕೇಸ?
Lord, there is one more issue.
Yes.
The second issue, my lords, is with respect to the numbers. There, my lords, I am not going on the computation. I am on a principle that there were co-guarantors. That's the second issue. There was another co-guarantor who has been discharged.
You are the guarantor here?
I am the guarantor. And my lords, under the act, the definition of borrower includes a guarantor.
Even otherwise.
Therefore, my lords,
Justice E.S. Venkatramani
Yes.
ಅವರದ್ದು ಒಂದು very old judgment 86 ಇದೆ. He refers to another judgment of one Bombay High Court where Jinnah had argued the matter. Jinnah was a great lawyer. And again, don't create an issue that Justice Dikshit praises Jinnah. He was a great lawyer. This is what his December, Roses in December, MC Chagla says. Yes. I'm only repeating that. I share that opinion. Yes.
lords, therefore, there, my lords, the issue is admittedly that guarantor, the co-guarantor or co-surety has been discharged. He was co-surety in respect of the very same loan because there is a common notice issued under section 13(2) to both of us. However, strangely, the money that he has paid, which is a substantial sum, 43 crores, is sought to be offset against some other debt of the same borrower.
It is his money.
It is his money, which he has paid. He is co-guarantor for the same loan. So I say from the same loan, that amount must be deducted.
Who are you? It is his money.
But he has already paid to the bank. I am a co-surety.
That was in respect of what debt?
My respectful submission, my lord, is it was in respect of this very debt.
Then that amounts to considering on merits. Other ಮೇಲೆ view of the tribunal ಬೇಕಾಗ್ತದೆ. Other ಮೇಲೆ view of the tribunal is not available.
Lords, I will point out that the tribunal may have considered my point in my favor. I will point out from the order. These are the 2 points. Now, in respect of the first point, your lordship may please see, my lords, the
18.
judgment of the Honorable Madras High Court, which is at page 1.
Tena Benka.
Please, my lords. In that, it's a short judgment, if your lordship permits, my lords. I will go through the facts also. The petitioner, one of the borrowers, has challenged the conditional interim order of stay.
ಯಾವ page ನೋಡ್ತಾ ಇದ್ದೀವಿ? ನಿಮ್ಮ running page ಏನಿದೆ?
Running page 3, my lords, is where the judgment begins.
3.
3.
3 is a you are right. Mukhyopadhyaya.
Please.
The Chief Justice of that one, na? Yeah.
The petitioner, one of the borrowers, has challenged the conditional.
Which paragraph?
First para, my lords. It's just a 4 para.
Then go to the law.
Please, my lords. Para 3, my lords. At ink page 3.
Also independently challenge the action taken under. Also, what did he have preferred? A number to deposit some of it is 9 crores. Deposited 9 crores with the bank. It was contended by the petitioner. Some already deposited. No further amount could be signed. So, in the present case, we find that the very same claim, 2 sets of appeals pursuant to the direct 50%. We are not direct the subsequent. So, the deposit is loan centric.
Please,
not appeal centric.
not number of appeals. Although, my lords.
Though it is required to be paid.
Please,
when appeal is preferred.
Please,
the intent of the parliament appears to be that way, but not to punish the appellant as such, not to discourage appeal as such.
Please,
is your contention.
Please, that would be my contention.
How Kerala treated this matter?
Lord, Kerala, the facts may be slightly different, It was an appeal against an interlocutory order of the debts recovery tribunal and an appeal against the final order in the same proceedings. Therefore, the facts may be slightly different.
Whether appeal against interim order, appeal against final order, any differentiation in section 18? No.
Section 18 makes no difference.
No, sir. If you want to prefer appeal, you have to make the payment.
Please,
That,
please.
ಅದು ಅವ್ರ ಹೆಂಗೆ reasoning ಮಾಡ್ತಾರೆ?
The
Justice Chali.
please, my lords. The relevant paragraphs are paras 37 to 39,
37 to 39.
page number 20. My lords. Insofar as the issue raised by the appellant bank about the order passed by the DRAT, that given the pre-deposit ordered in AIR number so and so, no pre-deposit amount need to be deposited in AIR requires any interference at all, because the said appeal is nothing but an offshoot of the main appeal against the dismissal of the securitization appeal itself, which has no independent existence from the main appeal and probably vice versa. In sum and substance, they are one and the same. To put it otherwise, two appeals had to be filed in view of the findings rendered by the DRT in interlocutory application, challenging the maintainability of the securitization application and consequential dismissal of the same. In fact, what is under challenge before the appellate tribunal predominantly is the dismissal of TSA number so and so by the DRT. However, the order passed by the DRT in the interlocutory application is closely intertwined and interconnected, and therefore the findings may have to be rendered in the appeals on the basis of findings generated in the interlocutory application by the tribunal, thus dismissing the securitization appeal. It may be true that subsection 1 of section 18 contemplates appeal from any order.
It says there need not be one more pre-deposit at all.
Please. And the words, my lords, which I rely on are is closely intertwined and interconnected.
They say that at page para 38.
38. In my case, my lords, the two appeals for clarity are, one is against an possession order. It was not physical possession, but a notice affixing possession. The second is against the auction notice.
Yes.
And all sale notice and in respect of all further sale proceedings. Given at Supreme. There is one judgment, my lord, of the Honorable Supreme Court, where the Honorable Supreme Court says that if sale has taken place, then the amount that the auction purchaser has deposited will not inure to my benefit.
Please repeat.
Lords, if auction has taken place and auction purchaser has paid some monies to the bank, that sum will not fit. That is the borrower's benefit. In other words, my lords, I cannot say auction purchaser has anyways paid crore from what I have to deposit. The Honorable Supreme Court says that will not inure to your benefit. I am not seeking that benefit either.
Let us see the order of the DRAT. Please. How it reasons out, how it considers these views of one Kerala High Court, another Madras High Court.
Please,
How they see.
the order starts at page 63, annexure A.
63.
May I request my lords, your lordship to please come to page 85, para 29. That's where the Madras High Court decision is considered. Para 29 at page 85, running page 85.
Page 85.
Please, my lords.
Can you read from page 75? Because the discussion starts at 14.
Para 14.
Please, I will read from para 14.
If you don't mind. let's-
No, I will read from 14. 14, my lords, your lordship.
Loan is admitted.
75.
He or the guarantor. Go to para 14, next page.
Please.
It's limited, so and so term loan was sanctioned, so and so. Next to go to para 15.
Just 3 lines above para 15, my lords, is the finding in respect of the co-surety.
Yes.
Thus, Lingam and any landmark developer stood as guarantor for term loan 1 and term loan 2 for rupees 170 crore. The next main contention of learned senior counsel for petitioner is that as per guarantee date dated so and so, the appellant's liability was restricted to rupees 95 crore. Whereas as per the guarantee deed executed by Lingamaneni,
150 crore.
150 crore. Then my lords, discharging Lingamaneni on receiving 43.37 crore, which would amount to violation of the terms of the contract. This contention is refuted by the learned counsel for the first respondent on the ground that bank is empowered to vary the terms of the contract. In fact, there are terms subscribing to this view. Thus, it is necessary to point out important clauses of deed of guarantee dated so and so.
Para 20,
Please,
with the clause 20 they are referring to.
please.
Yes, you said 87.
29, my lords, is where the judgment of the Honorable Madras High Court is considered. Page 85.
The senior counsel
Relying on the judgment of the
Ramakrishna was submitted.
that it is not necessary to make
Make
pre-deposit
fine,
for
so-
both appeals for the reason that appeals arose out of the same proceedings. On the other hand, counsel for the first respondent submitted that each case has a separate cause of action leading to separate proceedings and appeal, therefore, pre-deposit should be made in each appeal separately. In Ramakrishna versus Dena Bank reported, the petitioner therein challenged the order of DRT Chennai ordering pre-deposit of rupees 8 crore. It was submitted that the petitioner's son independently challenged the action taken under Surface Act in a separate appeal.
It
And-
proceeds on cause-centric approach. DRAT has cause-centric approach,
Please,
not debt-centric approach.
please. But if I may only add,
Any debate in the parliament as to why 18 is coined?
that I'll check.
ಅದೇ ಡಿಬೇಟ್ ಮಾಡಿದ್ರೆ ಗೊತ್ತಾಗ್ತದೆ ವಾಟ್ ಇಸ್ ದಿ ಇಂಟೆಂಟ್ ಬರೀ ಲೆಟರ್ ಆಫ್ ಬ್ಲಾಕ್ ಲೆಟರ್ ಆಫ್ ಲಾದಿಂದ ಗೊತ್ತಾಗೋದಿಲ್ಲ
Please.
ವಾಟ್ ಪ್ರಾಂಪ್ಟೆಡ್ ದ ಲಾ ಮೇಕರ್ ಟು ಎನಾಕ್ಟ್ ಲೈಕ್ ದಿಸ್
I will check that.
that we have to, this is what Aaron Barak in the purposive interpretation of the statutes. It's a very good book, he says. The debate of the parliament will say why that is made. Certainly not to discourage appeal at all. Please, it's a matter of appeal. Appeal is a matter of right. This condition, whether this condition is cause-centric or condition is debt-centric. Please, only thing.
I'll check, my lords, if your lordship gives me time. Tomorrow, my lords, I will.
ನಾಳೆ ಇಟ್ಕೊಳ್ಳಿ ಪ್ಲೀಸ್ ನಾಳೆ ಆಗ್ಲಿಕ್ಕೆ ಮಂಡೇ ಇಟ್ಕೋಬೋದಾ
The only thing, my lord, is Monday is the date on
they have
which,
given the date there
please, my lords, on Monday, my appeals may be,
dismissed only.
they may.
No, that's my statement, but in fact, the petitions have already become
Please.
instructions.
Please look at para 31 if your lordship does.
3-1. I read that. The amount of rupees so and so, so and so.
ಅಲ್ಲ 3ನೇ ತಾರೀಕು ಕಟ್ಟಿಲ್ಲ ಅಪೀಲೇ 15ನೇ ತಾರೀಕು ಹಾಕಿದ್ದಾರೆ ಸೊ 3ನೇ ತಾರೀಕು ಕಟ್ಟಿಲ್ಲದೆ ಇರೋದ್ರಿಂದ ದಿ ಅಪೀಲ್ ಹ್ಯಾಸ್ ಮೀನ್
By Monday, I will
no,
deposit.
they have
10
not
crores.
deposited the first installment.
All right, we have held a deposit can be made subsequently. We have held that way, affirmed by the Supreme Court. Therefore, this argument will not. No, but this aspect is not, of course, I saw that Dena Bank I saw.
Well,
Justice Charles judgment also, just I saw.
Please,
We'll also go through.
please, my lords.
Anyway, we'll consider that also. Just debate
Please, my
law
lord.
commission.
I will bring,
Law commission recommendation
please, my lord.
or PR Andharujana's recommendation.
Please,
That
please.
act is made pursuant to his report.
Yes, yes.
Banking Reforms Commission, which he headed.
Please.
But ನೋಡ್ಕೊಂಬನ್ನಿ. I'll see that.
Monday.
Call this matter on Monday,
May I request for
Till then.
Tuesday, my lord?
Tuesday. Very good. Tuesday. Till then, the DRAT shall not precipitate the pending matter before it.
Great.
Okay. ಅದ್ ನೋಡ್ಕೊಂಬರ್ಬೇಕು. ಲಾ ಕಮಿಷನ್ ರಿಪೋರ್ಟ್ ತಗೊಂಬರ್ಬೇಕು.
Yeah,
PR Andharujana Commission report ಇದೆ. ಅದನ್ನು ತರ್ಬೇಕು. You are the great expert on banking law.
please.
Uh,
And Tannen, my lords, relevant extracts.
10 ಅನ್ನೊಂದು ತಗೊಂಬರ್ಬೇಕು. Okay.
Grateful.
Supreme Court remand matter transfer pricing for. Question number 234.
234, ನೋಡಮ್ಮ. 234. Yes. Allon sentence we have noted that similar questions are being debated in a matter in which hearing is ongoing. Yes.
Your Lordship, this is also Supreme Court remand matter, my Lord. Question number 2, 3, and the question of law, now I have, which I have framed, my Lord.
2, 3 ಮಾಡ್ಕೋಬೇಕು. ಅಲ್ಲಿ and the additional question, substantial question of law submitted by the panel counsel, which reads as 2, 3, ಇದನ್ನು 4 ಆಗಿ treat ಮಾಡಿ. Additional question. Okay. Next.
Your Lordship, 27, my Lord, the connected matter, my Lord, in ITA 414 of 2022 arising out of the common order.
Admitted.
Dismissed, my Lord.
Dismissed. Worked. The subject matter of this appeal is substantially similar to the one in ITA number 414 of 2022 between Commissioner of Income Tax versus Messrs. Dell International Services, disposed of by a coordinate bench of this court, wide order dated 6/2/2023. First.
Which is also arising out of the common order, my Lord.
Learned counsel Enta Gaud ante ಹೇಳ್ತಿಲ್ಲ Mahima Gaud, appearing for counsel on record for the SSC, submits that the said appeal by the at the hands of the coordinate bench related to the common order, the very same order, common order, and therefore the fate of this appeal should be the fate of that appeal, which is dismissed. First, we agree with this. Next, in the above circumstances, appeal is dismissed, courts having been made easy. First, subject to the same terms as are incorporated in the coordinate judgment. Yes.
Lordship, transfer pricing issue, my Lord.
Question numbers? No,
1 and 2, my Lord.
1 and 2. ಕೆಳಗಡೆ add ಮಾಡಬೇಕು. Same matter, so it's.
My lord, may I say something?
Yes.
This kindly may be taken up after the hearing that currently my lord is
ಯಾವುದು?
29.
29, next, 1 second.
I'm sorry.
He wants time.
Yes, my Lord.
Rao wants time.
It may be adjourned.
Mr. Rao, can we call this after 2 weeks?
My lord is hearing 6 weeks because my lord is hearing the other matter. Yesterday my lord has kept it like that. The same may kindly be considered here also.
6 weeks, it may be adjourned, my Lord.
6 weeks. 6 weeks.
Obliged, my lord.
28 ಆಯ್ತು.
ಇಲ್ಲ, ಅವರು 29 adjournment ಕೇಳಿದ್ದು.
ಅದೇ 29 adjournment ಆಯ್ತು. 28 is over, na?
28 is admitted.
Admitted.
29 adjourned for.
ಏನು questions ಏನು? ಯಾವುದು question numbers ಏನು? All questions?
1 and 2, my Lord.
1 and 2. 31. Yes, Mr. Chauhan.
For the appellant.
Ha.
My Lord, this matter pertains to the issue whether the sale of customized software by the assessee amounts to accessible goods or service, my lord.
Sale of
Customized software, my lord, along with hardware, along with hardware, which is
But, what Apex Court said in that question whether the SIM card is
my
the
lord.
goods or services and a question it. What it say?
There they have held it as goods, my lord, because there, my lord, whether if it is a out of shelf software any software package, pen drive, CVD, that thing, my lord, can be considered as goods because it is already embedded in the tangible material, that is CD or something, my lord. Here, the assessee customizes the software according to the requirements of his client, my lord. He purchases a software, customizes it according to the requirement of the client. Clients are steel factories and all those things, my lord. Along with that, he provides the hardware, that is the control, distributed control system or field control systems, my lord.
How this question is treated by any of the high courts in the country?
My lord, this is not
Not considered. And no high court has said anything about this?
No, actually, the tribunal order is in my favor, my lord. I have not been
Tribunal
served a
order.
notice. Let them give a notice, I will accept and file wakalat. I have not filed yet.
But good.
I'll
Question
serve,
number-
I'll serve.
Which is that question?
Papers, let him serve, so that I can file
Question number
counter.
30.
Actually, our submission is that the matter should go to Supreme Court because it involves taxability. Under 35L of the Central Excise Act, which is made applicable to service tax matter. But anyhow, now I cannot speak because I have not filed a wakalat. I'll file it, I'll accept notice. And I'll
Six
file it
questions
on.
have raised, my lord.
Huh?
6 questions.
6 questions.
6 questions. Why it is required is, my lord, because there was an amendment in the Service Tax, the Finance Act, wherein they brought in the information technology system, my lord, in 2008 into the Finance Act. That is where we started saying that now we have to
Your contention is it's a
it's a service.
service.
Service, just
Suppose if it is goods, not it is exempted from tax.
That is a finding
yes.
of the tribunal, my lord, that it is
If it is
good
goods, it's exempted.
and
there
goods
is a
are
notification.
exempted.
that is a dispute. my lord.
Therefore, that question arises.
That's where that question arises. Therefore, it should go to Supreme Court, actually prima facie, my lord.
Why?
Because under 35L, High Court has jurisdiction to hear matters only which
Services.
are other than valuation or classification and which is pertaining to the taxability. Here it is a question of taxability.
No, taxability is on the premise
Yes,
whether it is goods or it is services.
service, correct.
Suppose
correct.
if we come to the conclusion that it's a taxable service, then therefore, every question need not go to apex court. If only where we are not in a position to decide
Yes.
because of the scheme of the act, then it can go.
Obliged.
Notice
I'll file my
that's what,
counter.
that's what. Yeah, issue,
I'll serve the call.
issue notice.
And there are 2 more matters. Actually, the
Fine,
order
so
comprised of 6
appears
matters.
for-
Only 4 have been listed. All
Call,
the 6
call
I
this
will
matter along with, ಕೊಡಿ ಯಾವ್ದು
ಇಲ್ಲ ಅದಿನ್ನ ಬಂದಿಲ್ಲ ಸರ್ ಇಟ್ಸ್ ಫ್ರೆಶ್
ಬಂದಿಲ್ವಾ?
ಮ್ಯಾಟರ್ಸ್ 6 ಮ್ಯಾಟರ್ಸ್ ಕಾಮನ್ ಅಪೀಲ್ 4 ಮಾತ್ರ ಇವತ್ತು ಪೋಸ್ಟ್ ಆಗಿದೆ ಇನ್ನ 2 ಐಲ್ ಓದಿರಿ
ಕಾಲ್ ವೀಕ್ ಆಫ್ಟರ್ ನೆಕ್ಸ್ಟ್.
All the 6 will
That's
be
what.
taken
But
up.
let it come. ನಾಳೆ ಬರ್ಬೇಕಲ್ಲ ಅವಾಗ ಜಾಯಿನ್ ಮಾಡಿಸ್ಬಿಡಿ ಈ ನಂಬರ್ ನೋಡ್ಕೊಂಡು ಅವುಗಳನ್ನು
ಅದನ್ನು ಜಾಯಿನ್ ಮಾಡಿ ಐಲ್ ಜಾಯಿನ್
ಕಾಮನ್ ಸೇಮ್
ಎಸ್ ಕಾಮನ್ ಮೈ ಲಾರ್ಡ್ 30 to 30
ವಿತ್ ಈಚ್ ಅದರ್. ಅವ್ರಿಗೆ ಕಾಪಿ ಕೊಡಿ.
ಕಾಪಿ ಕೊಟ್ಟು
ಗಿವ್ ಕಾಪಿ. ಯು ಆರ್ ಕಮಿಂಗ್ ಫ್ರಮ್ ಮಡ್ರಾಸ್?
I accept notice.
ಫ್ರಮ್ ಬೆಂಗಳೂರು.
Bangalore only. Bangalore. Only.
All.
4 weeks time may be given.
Call after 4 weeks.
Certify, my lords, I appear for the respondent.
So I think it may be adjourned for 4 weeks, the Supreme Court remand matter relating to transfer pricing.
Transfer pricing. ನೋಡಮ್ಮ. Call after 6 weeks. Since a connected matter is being argued. Okay.
Please.
Grateful, my lord.
ಅಣ್ಣಾಮಲೈ ಏನಿದೆ?
Lord, this matter is squarely covered by the Honorable Supreme Court decision in the case of engineering analysis, my lord.
Not covered.
Lord, each case, my lord, each agreement has to be examined.
Therefore,
With
we
the-
said, show the agreement.
My lord, it's in the SSC's appeal, it's SSC's appeal.
Huh?
Agreement is
SSC's appeal, if my lordship sees, both the appellate authorities have.
Which is produced before tribunal, produced before assessing officer.
ಅವ್ರಿಗೆ ಒಂದು ಕಾಪಿ.
But
Yes,
both
my
the-
given copy, my lord. Please see, my lord, at
Appellate
page number.
authorities.
ಒಂದ್ ನಿಮಿಷ ಅವ್ರು ಏನ್ ಹೇಳ್ತಾರೆ ಸ್ವಲ್ಪ ಲಕ್ಷ
If my lordship sees the order of the tribunal merely said, my lord, at that point of time, Samsung decision was in favor of the revenue. It said, okay, we'll apply Samsung without going through the agreement or anything. And it came in favor of the revenue.
It all depends upon terms of the agreement.
That's why if my lordship,
ಇದರಲ್ಲಿರೋ ಟರ್ಮ್ಸ್ ಎಲ್ಲಿದೆ ತೋರಿಸಿ.
my lordship sees, my lord, the order of the apex court, my lord, in the case of engineering analysis.
ಹಾ,
My lord, page number
ಅಲ್ಲಿ agreement
76 ಅಲ್ಲಿ, while discussing, my lord, I am just referring to the
ಕಾರ
judgment.
ಹೇಳಿ ಪೇಜ್ ಇಲ್ಲ ಅದಕ್ಕೆ.
My lord, para 15, internal 15, that is in 152, page 77, left side ಅಲ್ಲಿ 76. ಅಲ್ಲ, 152, page internal 15, 76 ಆಗತ್ತೆ actually. To the
ಇದರಲ್ಲಿ
right side it is 77 ಅಂತ ಇದೆ.
ಪ್ಯಾರಾ ಪೇಜ್
Page, right side it is 77, right side page. Internal 77 out of 83. Para 152 ಆಗತ್ತೆ actually ಅದು. Where para 153 starts, it is actually internal 76.
Before.
You're right.
My lord, while discussing royalty issue, my lord, the court refers to, my lord, I am reading para 15 internal.
150.
ಅಲ್ಲ,
ಪ್ಯಾರಾ 15.
15.
Where consideration is
Consideration
paid.
paid for the transfer of full ownership of the rights in the copyright, the payment cannot represent royalty and the provisions of the article are not applicable. Difficulties can arise where
There is transfer of rights
rights,
involved.
etc. They go through, and 16 they say, each case will depend
Depend
on
upon
particular facts of the case. So that has not been examined either by the first appellate authority or the second or the tribunal. If my lord and friend is, my lord, agreeable to send the matter back to the tribunal or the first appellate authority, my lord, let the agreements be my lord, examined in relation to the applicability of this judgment rendered by the Honorable Apex Court. Then, my lord,
ಅಲ್ಲಿ ಪ್ಯಾರಾ 15 ಓದಿದ್ರಲ್ಲ ನೀವು,
ಹಾ.
15, 16.
please.
ಅದು OECD. OECD.
Because royalty was referred to. It starts from, my lord, page number 73. So each case, my lord, like my learned friend yesterday made a submission, every case
Depends upon
depends upon the agreement.
facts and circumstances of
That
that
exercise
case.
has to be done by the, my lord, fact-finding authorities. So it can go back, my lord, if my learned friend agrees. My lord.
Depend my burn.
40.
ಯಾವ್ದು ಆಸ್ಪೆಕ್ಟ್ ಕನ್ಸಿಡರ್ ಆಗಬೇಕು.
Your lordship's can print para 45 and also 47, my lord.
45, 47 ನಾ?
47.
ಪೇಜ್ ಏನು?
Page, my lord, 30, 30,
Page 30.
internal 30.
What the Honorable Supreme Court says, my lord, if software is supplied to Indian company and some rights are given, whether your lordship, one non-resident company gives software to the Indian company, with just simple supply of software, royalty is not applicable. If any right in that software
Is created.
you make duplicate into multiple copies and sell it, royalty is applicable. Or if the non-resident company supplies software, and if the information in the
So
software
ultimately it depends upon the terms of the
terms
agreement.
of the agreement. Your lordship,
ಅದು agreement ಇದೆ ನಿಮ್ಮಲ್ಲಿ ಕಾಪಿ.
My lord, I have given my
your
lord.
lordship, the problem is not this.
Please see page number 38 of
Condition,
the.
the parameters set down by the Supreme Court was not there prior to that judgment. The understanding of the department was not at all that we only canvass that if supply of software is there, royalty is applicable. These parameters, the new principles which had been laid down by Honorable Supreme Court was not there until Samsung case. This Honorable Court Samsung case and also Synopsys case hold that if there is supply of software, royalty is applicable. The Honorable Supreme Court has given a different dimension.
ಬರೀ ಅದು ಒಂದ ಫ್ಯಾಕ್ಟರ್ ಅಲ್ಲ ಅಂತ.
And one the factor, your lordship, 4 types of agreements were dealt in the engineering analysis. Now, my lord, more than 40 cases are pending before this Honorable Court. Your lordship, now this Honorable Court has to remit to the matter to some authority to analyze the agreements if the parameters set down by the Honorable Supreme Court, my lord, is satisfied or not. to attract royalty. So royalty
ಬೇರೆ
definitely,
ಮ್ಯಾಟರ್ಸ್ ಯಾವುವು?
ಬೇರೆ list ಇದೆ ನೆನ್ನೆ, well, daily matters are coming up, my lord. We can make a list, my lord.
ಎಷ್ಟೋ ಅವನ್ನೆಲ್ಲ ನೋಡ್ಕೊಂಡು
Yes, my lord.
ಒಂದು ಆರ್ಡರ್ ಮಾಡಿಬಿಟ್ರೆ
Please, my lord.
ಅದು ಯಾವತ್ತು ಹಾಕೊಳ್ಳು. ಇದು ಒಂದು.
ಇದೊಂದು.
ಸಪೋಸ್ ಅಗ್ರಿಮೆಂಟ್ ಅನ್ನು ನಾವೇ ನೋಡ್ಲಿಕ್ಕೆ ಬರಂಗಿದ್ರೆ
Your lordship may kindly see, in many of the cases, my lord, each agreement has to be seen. In prior to that, my lord, the assessing authority was not having this type of
you
knowledge.
said that, you
ಅಲ್ಲ,
said that.
agreement copies ಇರ್ಲಿಲ್ಲ.
ಅಲ್ಲ,
Now, he had not even summoned the agreement copies. Supply of software and ತಕ್ಷಣ royalty ಹಾಕ್ಬಿಡ್ತಿದ್ರು.
ಸ್ವಲ್ಪ ಕೇಳ್ಕೊಳ್ಳಿ.
Yes,
ಸುಮ್ಮನೆ
I'm
ಏನೋ
sorry.
ಒಂದು ಹೇಳ್ಬೇಡಿ. ಲಾ ಗೊತ್ತಿಲ್ಲ. Supreme Court says interpretation of a document is a question of law. ಅದಕ್ಕೆ ಹೇಳಿದ್ದು. This is on substantial question of.
Yes, my lord.
If you feel, I agree only to the extent of para 1516, which your friend at that OECD. 1516, it depends upon individual case.
Individual.
Agree. ಅದಕ್ಕೆ that individual case arises because of terms of the agreement. ಆ terms of the agreement ನೀವೇನಲ್ಲ ಟ್ರೈಬ್ಯುನಲ್ ನಲ್ಲಿ ಓರಲ್ ಎವಿಡೆನ್ಸ್ ಮಾಡಲ್ಲ. ಕರೆಕ್ಟಾ? ಅಗ್ರಿಮೆಂಟ್ ಅನ್ನು ನೋಡ್ತೀರಿ, ಇಬ್ರು ಆರ್ಗ್ಯೂ ಮಾಡ್ತೀರಿ. ಅದನ್ನ ನಾವ್ಯಾಕೆ ಮಾಡ್ಲಿಕ್ಕೆ ಬರಲ್ಲ ಅನ್ಕೋತೀರಾ? ನಾವು ಟ್ರೈಬ್ಯುನಲ್ನವರು ನಮ್ಗಿಂತ ಜಾಣರು ಇರ್ಬೋದಿಲ್ಲ ಅಂತ ಹೇಳಲ್ಲ, ಆದ್ರೆ ನಾವು ದಡ್ರಲ್ಲ ಅನ್ನೋದು ನಮ್ಮ ಇಂಪ್ರೆಷನ್.
Without any foundation relating to the facts, my lord, because it is a factual matrix, my lord.
ಹಾಗಾದ್ರೆ ಫಸ್ಟ್ ಕೋರ್ಟಿಗೆ ಹೋಗ್ಬೇಕಾಗ್ತದೆ, ಫಸ್ಟ್ ಅಥಾರಿಟಿಗೆ ಹೋಗ್ಬೇಕಾಗ್ತದೆ.
First, any of the authorities, your
Another 5 years ಫೈಟ್ ಮಾಡ್ಕೊಂಡು ಕೂಡ್ಬೇಕು ಆ ಸಿಟಿಜನ್.
Your lordship may know, now the law is settled, my lord, because of engineering analysis, my lord, the Supreme Court dealt with more than hundreds of cases. In the first case, only the Honorable Supreme Court dealt with clauses of each agreement. In remaining cases, I'll note later.
ನಿಮ್ ಲಿಸ್ಟ್ ಕೊಡಿ,
ಅದಕ್ಕೆ review petition.
ಅದ್ರ ಲಿಸ್ಟ್ ಕೊಡಿ, ನೋಡ್ಕೊಂಡು ಇವನ್ನೆಲ್ಲ ಅಷ್ಟನ್ನು ಒಂದಿವ್ಸ ಪೋಸ್ಟ್ ಮಾಡಿಕೊಂಡು
I will furnish the list tomorrow.
ಹಾಕಿ, ಲಿಸ್ಟ್ ಹಾಕಿ. ಅಣ್ಣಾಮಲೈ ಲಿಸ್ಟ್ ಹಾಕಿ. ಕಾಲ್ ದಿಸ್ ಮ್ಯಾಟರ್ ನೆಕ್ಸ್ಟ್ ವೀಕ್ ಹಾಕೋಣ. ನೆಕ್ಸ್ಟ್ ವೀಕ್ along with
Week after next.
week after next, along with other pending matters, list of which would be given by the panel advocates for the revenue.
Please.
File the
Interpretation of document is considered as substantial question of law. Of course, ಅದನ್ನೆಲ್ಲ ಮಾಡ್ಕೊತ ಕೊಡಕ್ ಆಗಲ್ಲ ಅನ್ನೋದು ಒಂದು, ಅಲ್ಲಿ ಸ್ಟಾರ್ಟ್ ಆಗ್ಲಿ ಅಂತ. ಹಂಗಾಗಿ ನಾವು ಒರಿಜಿನಲ್ ಅಥಾರಿಟಿಗೆ ಹಾಕಿರ್ ಮತ್ತಲ್ಲಿ ಒಂದು 5 ವರ್ಷ, ಅದಾದ್ಮೇಲೆ ಮತ್ತೆ ಅಪೀಲ್ ಟ್ರೈಬ್ಯುನಲ್
Because we
ಹಾಕಿ
have given refund in all the cases, my lord. Only in exceptional cases like the assessee has lost. We are in majority of the cases, we are in appeal, my lord.
ಇಂತೋಳಿ ಅವ್ರಿಗೆ ಕೊಡಿ, ಅವ್ರಿಗೆ ಕೊಟ್ಟುಬಿಡಿ, ಅವತ್ತು ಕೊಡಿ.
No, my lord, it can be
ಇಟ್ಕೋಬೋದಾ?
built some, that agreement copy is available, my lord. Already filed before lower authorities.
ಅಲ್ಲ, ಅದು ಅಗ್ರಿಮೆಂಟ್ ಅವೈಲೇಬಲ್ ಈಗ ಮಾಡಿರಿ.
No,
They were
before lower
original-
authorities, before assessing
But
officers.
tribunal has not considered.
Yes, my lord.
It was
Tribunal
not
consider
examined, it was
ಮಾಡ್ಬೇಕಾಗತ್ತೆ.
not placed before the tribunal.
No, because after this decision, it was placed before tribunal. That paper book only I filed, my lord.
ನೋಡ್ಕೊಳ್ಳಿ. ಹಾಲು.
Respondent.
Your lordships, just seeking for a passover, your lordships, my senior.
Passover?
Senior.
ಕೊಡ್ಬೋದಾ? ಓಕೆ, ಪಾಸ್.
So appearing for the appellant, my lords, kindly
Ah.
2 weeks time may be granted, my lords. It is reallocated file, my lords.
Reallocated to
Yes,
you.
please. my lords.
After 2 weeks,
Yes, please. my lords.
call after 2 weeks at the request of Mr. Shetty.
Obliged.
Delete my keep. ವನಿತಾಕ್ಕೆ ಯಾರನ್ನ ಇದು ಮಾಡೋಣ?
Yes, please.
Name to be deleted. Obliged, since he has ceased it to be member on the panel. Counsel on the panel. Yes.
Office may be directed to show name of Arvind Chavan, my lord.
Arvind Chavana,
Arvind Chavan's name.
say, registry to show name of Miss Arvind Chavan in the place of Mr. Deshpande, who is permitted to retire.
My lords,
Okay.
if I may mention one thing, the appeal has been filed, the department appeal has been filed against a learned single member order of the Sestat, which is now being, the duty demand, which was set aside by the learned, by the honorable Sestat, was only 34 lakhs. It's now being hit by the monetary limit, my lords, which is 1 crore
ನೋಡ್ಕೊಂಡು ಹೇಳಿ,
in terms of the.
ನೋಡ್ಕೊಂಡು ಹೇಳಿ. Let him see. That circular,
Monday.
Yes, my lord.
2024 circular,
ಇಲ್ಲ 16 ದಾಗೆ ಬಂದು
16 ದಾಗ ಬರ್ತದೆ.
16 ದಾಗೆ ಬಂದು
What should I have it on Monday?
Ah.
Just not Monday.
Call
Monday at least.
Monday. At the request of.
Correct.
Yes. Ah. Ashok,
Matter pertaining to regularization, he was appointed in 1993. Not thereafter his name also has been sponsored by the employment exchange. Till now, there, even though employment,
labor.
I think because of the order was made by the honorable judge, former judge of this honorable court, the writ petition has been posted before the division bench of this honorable court. It is a.
ಹೇಳಿ ಅವ್ರು ಯಾರು ಇಲ್ಲ.
Yes.
ಚೇರ್ಮನ್ ಕರ್ನಾಟಕ ಗ್ರಾಮೀಣ ಬ್ಯಾಂಕ್ BC ಪ್ರಭಾಕರ್ ಯಾರು ಇಲ್ಲ ಅವರು. ಮತ್ತೆ ಅವ್ರಿಗೆ ಅವ್ರನ್ನ ಕರೀರಿ ಒಂದ್ ಸ್ವಲ್ಪ ಕರ್ಕೊಂಡ್ ಬಂದ್ರೆ ನಾವ್ ಏನಾರ ಮಾಡ್ಬೋದು ಪೆಂಡಿಂಗ್ ಮ್ಯಾಟರ್. ಯಾರು ಅಪಿಯರ್ ಆಗ್ತಾರೆ BC ಪ್ರಭಾಕರ್ ಯಾರು ಬರ್ತಾರಲ್ಲ ಸುಬ್ರಹ್ಮಣ್ಯ ಫೋನ್ ಮಾಡ್ತೀವಿ ಕರೀರಿ ಪಾಸ್ ಓವರ್.
My lord, senior counsel has been engaged in the matter, my lord. May I seek for a short pass over?
ನೀವು ಸ್ಟಾರ್ಟ್ ಮಾಡಿ. If there is any difficulty, we will give time. Don't worry. Start ಮಾಡ್ಬೋದು ತಾನೆ? Whether your client will mistake.
Please, my lord.
Whether your client will mistake if you start that.
No, certainly not, my lord.
Start
My lord, there are three.
with a lot of preparation, Mr. Aditya. He comes with lot of preparation. I have seen him.
Dear friend, now on the opposite side.
Oh, he comes with lot of preparation.
Please, oblige.
Because I remember in one minimum wages matter,
Please.
you had argued. that.
Please.
Correct.
Oblige. My lord, there are three petitions, my lord, emanating out of a proceeding initiated by the land grabbing court, my lord.
Ah.
My lord, my lordships had vide an order held that not to precipitate the matter, my lord. Now, my lord, this matter has been listed. We were intending to file an application for stay of further proceedings, but the matter got listed. My lord, what happened on 2nd of January before the land grabbing court is that the court proceeds to take cognizance of the matters despite there being an order not to take precipitative action, my lord. Out of the three matters, one matter we had moved before my lordships. My lordships was pleased to once again clarify to state that there shall be stay of further proceedings. That matter alone, my lord, there is no stay of further proceeding.
Direct judges for that.
Tell your members
That's what this is to
when they have taken.
Please, may I pass on the memos, man? IAs, man. My lord may kindly peruse the order of the land grabbing court, my lord, which has been produced by me at page number Annexure G at page 12, my lord, but the order of cognizance is at page 16, my lord. My lords may kindly turn to page 16, my lord.
ನಿಮ್ಮ senior advocate ಬರ್ಲಿ. In the meanwhile, we'll speak to the members.
Please.
Because many such matters are coming.
Please, my lord.
Even when there is an order, it is headed by High Court judge.
second, third matter.
Please,
Huh?
The second or third.
No, third matter,
please,
230 matter.
please,
Senior advocate ಕರ್ಕೊಂಬನ್ನಿ.
please.
serial number 14 admit ಮಾಡಿದ್ರೆ 14 ಡಿಲೇ ಕಂಡೋನ್ ಆಯ್ತು. ಅಡ್ಮಿಟ್ ಅಲ್ಲ.
Monday.
ಪಾಸ್ ಓವರ್ ಯಾವಾಗ 2:30ಗೆನಾ?
2:30 PM bench. Continuation ಇದೆಯಲ್ಲ 51 ಇದೆ. One. First is that. ಇದೆಲ್ಲ ಟೋಟಲ್ 8 ತಾರೆ. ಸರಿ.
23 particular date ಕೊಟ್ಟಿದ್ದಾರೆ ಇಲ್ಲ only agenda ಮಾರ್ನಿಂಗ್ ಇದು ತಗೊಂಡ್ರು ಅವರು 4 weeks sir.
ಜಾಸ್ತಿ ಮಾಡ್ಬಿಡ್ತಾರೆ 25,000 ಅಂತ ಹೇಳೋರೆ ಆಲ್ರೆಡಿ.
ಬೆಟರ್ ಅಫಿಡವಿಟ್ ಬಂದಿದೆ 2:30
ಅದು 4 ಮೀಟರ್ ಅಡ್ಮಿಟ್ ಆಗಿದೆ. ಅದೇ ಕ್ವಶನ್ ಸಪ್ಲೈ ಯಾವುದು ಅಂತ
ಸರ್ 45 ನಮ್ಮ ಮಿಸ್ಟರ್ ಸುಬ್ರಹ್ಮಣ್ಯ ವಾಸ್ ರೆಡಿ. ಅನ್ಫಾರ್ಚುನೇಟ್ಲಿ ಅವರು ಆನ್ಲೈನ್ ಅಲ್ಲಿ ಬರೋದಕ್ಕೆ ಕಳ್ಬಿಟ್ಟಿದ್ದಾರೆ. ವಿ ಆರ್ ರೆಡಿ 2:30 ಪ್ಲೀಸ್.
ನಮ್ಗೆ ಮೇಡಮ್ ಗೌರ್ಮೆಂಟ್ಗೆ
ಆಥರ್ ಆಗಿದೆಯಾ? ಯಾಕೆ ಸರ್ ಅದು ಇದಾಗ್ಬಿಟ್ಟದು? ಅವ್ರಿದ್ರು ಅದರ್ ಸೈಡ್ ಇದ್ರಂತ
as part of your registration certificate. You have not used those items for the purposes of manufacture. Therefore, you have misdeclared as part of your registration certificate, and therefore we're imposing a penalty on you. We responded. They gave us an opportunity for hearing. We responded. After submitting the response, they issue a final order saying that, yes, indeed, you have not used it for the purposes
So
of
1.5 times.
1.5 times, they impose a penalty. Now, against that, my lord, I filed a rectification. Because, my lords, what has happened is there are two.
Rectification is a review-like thing.
It's a rectification when there is only a mistake in fact or law, fact, my lords, not even law. When there is a mistake on fact, my lords.
Like a review only.
Review slightly different. Review will be on law also, a little bit on law also, my lords. This is only on fact.
Okay.
What has happened is, my lords, there are two registration certificates here. There is one that is issued in 2005, and there is another amended one which is issued in 2009, with effect from 2005.
With retrospective effect.
With retrospective effect. He has only,
Which he has seen.
he has seen only the 2005 one.
Okay.
He has not seen the 2009 one. We also demonstrated to him, my lord, that there are some judgments that you have not taken into consideration. Kindly look at this again. The rectification, my lords, he says we will not look at the rectification. He issues an endorsement. Now, against the
Rejecting endorsement.
he's giving an endorsement saying that you please pay this 1.5 times penalty.
Yes.
Against this endorsement, my lord, we go on first appeal.
Yes.
The first appellate authority looks at the entire picture and he says, no, this is incorrect. He rules in my favor, saying that it is completely, you are completely within the bounds of your registration certificate. There is a rule.
2009.
Because of the 9, it is there. There is no Mr. Declaration, and you have also used it in the course of manufacture only. Because, my lords, the items which it's in question here, my lords, are those glass cooling chambers, etc., my lords. So, my lords, once I make the product, it has to be cooled in a chamber. So, for that, I need to make a glass cooling chamber.
You are the manufacturer also.
I am the manufacturer also. So, it is during the course of this manufacture, my lords, that I'm using these equipments. It may not be manufactured by itself. I may not manufacture the glass equipments, but I buy it, I make a chamber, etc.
Sir, there is a new goods coming into existence. But that issue will not, it's not excise matter.
No, my lords. No, my lords.
Anyway, understood.
Now, my lords, he rules in my favor saying that, no, this is correct. Registration certificate is right. You have used
So
it.
they went in appeal.
No, my lords, they filed a revision against this.
Against that.
They filed a revision against this. Today, I stand before my lords on a revisionary order saying that the
First
first.
against you.
Yes, my lords. He says the first appellate authority's order is incorrect. I go back to the original order that stands, and therefore I'm before my lords on this, my lords.
Show your 2009 certificate.
My lords. That is the compilation, but I will also point out from the order itself, my lords.
Ah. Please share a copy with your friend also. Exactly.
My lords may have the first two pages of this law. Yes, my lords. My lords may see page number 1, my lords.
First is 2005.
Yes, my lords. My lords may have this at the somewhere in the middle, my lords. Somewhere in the middle. This certificate is valid from 1/4/2005 until cancelled.
Not yet
My lords
cancelled.
have that, my lords. In the middle, my lords, this certificate is valid from just below the table.
This certificate is valid from 1/4/2005
until cancelled. Next page, my lords. This is the original commodities list. Page number 2, my lords. On the left side, my lords.
24/2/2005. This 2009. This is from 2000, it is valid from so and so.
No, my lords, my lords, the page number 2 on the left side, my lords.
2.
There is a commodities list. This is the
Paracetamol,
Yes. Ibuprofen.
glibendamide.
Yes, my lords. All pharmaceutical products, my lords.
Ah.
This is the original list as it stood at that point of time, my lords.
All right.
Now, my lords may have page number 3.
Which
This is
other
the-
item you have added to this?
My lords, on page number 4, my lords may have pharma products, including capital goods.
Okay.
Including capital goods, my lords. For a moment, my lords may have the first appellate authority's order.
Where is the retrospective effect to
My
this
lords,
certificate?
my lords may have the certificate,
Valid from
page page 3, my lords, again, this certificate is valid from 1/4/2005 until cancelled.
Now, which section says certificate can be given with retrospective effect?
I'll point that out.
Is there?
Might I have this? Yes, my lords. I'll point.
Aditya, is it there, is there a provision to grant a certificate with retrospective effect?
It's appears to be what I think what happens is if an application is made and the certificate is granted later, the certificate dates back to the date of the application.
Application, which application? Original application or this application?
The application for inclusion
Amendment.
of the amendment of the original section itself. I'll just point out, my lord,
With
section.
retrospective effect, it can grant.
It doesn't use the word retrospective, my lords. I should submit that. But what it does allow, my lords, is for an amendment, my lords. My lords may have,
Your argument is amendment will be retrospective.
my lords, because as of now, my lords, the certificate says it is valid from
How courts
2005.
have answered this question?
On this point, I'll have to check, my lords. On
Don't
this,
you mind?
on this
That will
point,
be very important.
my lords, I'll check
Suppose
that.
if there is no enablement, empowerment to grant certificate with retrospective effect, it appears that way to me. At least Jain and Jain, the administrative law, which our Arade Sahib has revised. He says like that. It was in connection with some excise law. There, the certificate was, the form was issued by adding one more commodity. Question arose whether this addition is with retrospective effect. Then one High Court said it is not. That's discussed by Arade Sahib.
If I can just, my lords, on page number 3, my lords, assuming, my lords, it is not retrospective.
It makes no difference.
It makes no difference because, my lords, this is dated.
This transaction happened on which date?
The 2009 to 2014 is the period of transaction, my lords.
This is a post certificate,
This is
post
24.
amendment certificate.
Yes, my lords.
Okay.
Even assuming it is valid from 2009, my lords, because I have conducted the capital goods transaction only after this amendment came into me. So
So
this
that question
happened in
will not-
2009.
Understood.
This happened in 2009.
Now go to how tribunal treated this.
My lords, may I have the
subject?
first appellate authority's order.
Ah.
Is that,
Now go to tribunal's order.
no, my lords, this has come from a revision before my
Reason
SMR.
itself. You did not go to tribunal at all.
Yes,
You want to go. Okay.
My lords may have, this is at annexure C, my lords, page 60, sorry, my lords, annexure D, my lords, page 62. I'll straight away take my lords to the relevant portion.
62.
Annexure D, my lords.
Yeah, you are right.
My lords, I'm sorry, my lords, may have page number 92, which is the discussion on this, because till then, my lords, is all submissions.
92.
92, my lords. Before that, my lords, can I go take my lords through the provisions, my lords?
Which provision?
There is a section 8 and there is a section 10 and rule 13 that I want to take my lords.
Yes, yes. We'll come with you. No problem. Section
In this compilation, my lords,
in your compilation.
in my compilation file. Page number 5, my lords. Relevant page is at page number 7.
7. Rates of tax.
Section 8, my lords. I'll just read 8.1 and I'll jump to 8.3, my lords.
Well,
Rates of tax on sales in the course of interstate trade or commerce. 1. Every dealer who in the course of interstate trade or commerce sells to a registered dealer goods of the description referred to in subsection.
dealer
3.
goods, registered
The-
dealer,
there is-
of goods.
There are two. There is a difference between dealer and registered dealer, my lords.
Okay.
Dealer is every person who's
Can be
transacting
dealer.
in
Dealer
goods.
is a genus, registered is a species.
Species.
Okay.
Subsection 3 shall be liable to pay tax under this act, which shall be, at that time it was 2% of his turnover, or at the rate applicable to the sale or purchase of such goods inside the appropriate state,
Under the
unless
sales
under the
tax
sales
law
tax
of
of
that
that state,
state.
whichever is low.
Ah.
My lords may now have 3, subsection 3. At the bottom, my lords.
You're right.
The goods referred to in subsection 1, B,
Goods of the.
are goods of the class or classes specified in the certificate of registration of the registered dealer, purchasing the goods as being intended for resale by him or subject to any rules made by the central government in this behalf for use by him in the manufacture or processing of goods for sale or in telecommunication network or mining or in the generation of distribution, so on and so forth, my lords. My lords, this will have to be read with Rule 13, my lords. My lords may have that at page number 14.
What you read is Rule 2 capital A.
No, my lords, 8.3b, my lords.
Huh?
3b,
you are.
3b, my lords.
3B.
8.3b.
You are right. 3B. 3 is introduced on 2002.
My lords.
You asked me to look.
My
into
lords may
which-
have page number 14, my lords. It's the rules.
Yeah.
Page number 15 is rule number
57
13.
rules. 57 rules, na?
Page number 15, my lords.
You are right. Ah,
13, my lords.
the goods.
The goods referred to in clause B of subsection 3 of section 8, which a registered dealer may purchase, shall be goods intended for use by him as raw materials, processing materials, machinery, plant, equipment, tools,
in the
stores.
manufacture
Yes,
or
ma'am.
processing of goods for sales or in mining, etc., etc.
Now, this 8.3b, my lords, and rule
8.3B has to be read with Rule 13.
Rule 13, my lords. My lords, for a moment may have the previous page, page number 11, which is the power for them to impose a penalty.
Page number 11.
11, my lords. Previous page. Penalties, my lords.
Penalties.
If any person, the relevant one will be B, my lords. If any person,
Being a registered dealer.
falsely represents when
class of-
purchasing any class of goods, that goods
He's
of such class are covered by his certificate of registration, or C also, my lords, not being a registered dealer falsely represents when purchasing goods in the course of interstate trades or commerce that he is a registered dealer.
But that C will not apply.
That
to
C
you.
will not apply also to me, my lords.
Only B applies.
Only B applies, my lords.
So you should have falsely represented when purchasing any class of goods.
Exactly, my lords.
If you falsely stated thereafter, that does not fit into the law.
No, my lords, what the presumption, my lords, is that when I have given them the application form, I have told them this is exactly the kind of equipment that I'm going to import. And if I say, for instance, cement, my lords, but I buy mud, for instance, if I buy cement and if I say,
What is meant by when purchasing any class of goods, Aditya? What is meant by that?
It's a classification method. That is, provided.
Being a registered dealer, that means registration precedes the fraud.
My lords,
Correct?
registration precedes the fraud.
Fraud. At what point of time he should have, while purchasing any class of goods,
Yes. Sir. What happens, my lord, is if your lordships take page 2 of what my learned friend.
ಅದೇನೋ ಇನ್ನೊಂದು ಎಂತದ್ದು ಫಾರ್ಮ್ ಸಿ ನ ಏನ್ ಹೇಳಿದ್ರಲ್ಲ ಅವ್ರು
Form C.
ಫಾರ್ಮ್ ಸಿ ಕೊಡುವಾಗಿದ್ದಾದ್ರೆ ಬಂದ್ಬಿಡತ್ತೆ ಅಂತನಾ?
ಹೌದು.
That appears to be.
capital, if for instance, my lord, capital goods is the circumstances here. Capital goods is a full homogeneous item, my lords. Now,
Correct.
under capital goods, you may have many other items. Now, if they say, for instance, that you have not got capital goods, you have got some other goods, but you're still issuing Form C for those
That could have
items.
been under,
Yes, ma'am.
but not this. sir.
Not this.
There is a subtle distinction. It's not capital goods. It is pharma products, which is the genus,
Correct.
including capital goods. So the pharma products has to necessarily attach to capital goods,
Not something else.
not something else.
Adjustum generis. Which item they have covered?
Kindly see. Kindly see. It's available in the
order of the.
You mean to say the goods which he sold to the gentleman seat, earlier there was lady. No, anyway, now we'll say gentleman. To the gentleman who was in Maharashtra, that goods does not fit into the class of the goods enumerated in 2009 certificate. Is it your case?
Lords, he purchases goods. He has a manufacturing unit.
Correct.
In that manufacturing unit, my lord, kindly see the C forms that were issued on page 30 is reproduced.
30.
30.
Of today's compilation or
No, my lords, in
petition?
the petition itself, STA, sales tax appeal.
Page
30.
Ah. 9 to order.
9.
Ah.
9 to order. 9 to order.
Yes.
It is noticed about the third paragraph.
Third paragraph.
Last. It is noticed that the assessee has issued C forms.
It notices that.
Yeah, your lordship, I actually have the previous paragraph also.
Huh?
Further, the
Previous.
place of manufacturing unit has been visited on 18/10/2016 for inspection. And during the course of inspection, team obtained a list of goods purchased against C forms, which have been reported by the inspection authority, which stands verified physically. It is noticed that these goods were used for erection and construction of manufacturing unit. None of these goods were part of plant and machinery or raw material consumables. Thereby, the purpose for which these commodities were purchased and were intended for use in the manufacturing.
They are not meant for manufacturing purposes, but he has put them in the structure itself.
Yeah. Now,
Plant, in the
kindly see.
plant he has put,
Yes.
not as the product.
Yes. Now kindly see what is the, what are the goods? It is noticed that the assessee has issued C forms for following items: clean room accessories and room accessories, including prefabricated clean rooms; glassware for factory doors housing raw materials and components; room accessories and clean room accessories, including the following items: high pharma walkable false ceiling, high pharma double skin walls, glasses, grills, aluminium covering, 90-degree corners, single sliding doors, double doors, view glasses on doors, change lockers, apron cupboards. Your lordships will
Also are not products at all. They will not fit into even 2009 amendment.
nothing matters. Now kindly see, my lords, the same is reproduced on page 56. Your lordship may also take, my apologies, may also take page 54. Your lordships have 54.
54.
Hence, the penalty payable on issue of C forms against instructed purchase of ineligible goods was proposed to be levied as under. Kindly see: ready garments, glasswares, restroom cubicles, urinal modesty cubicles, apron cupboards, civil wall doors, clean room items, doors,
Clean room.
room accessories. Then, my lords, may kindly then
Clean room accessories on
maybe bleach. It is for my lords. If I may point my lords to page number 55, which is the next page, my lords. Last paragraph at the bottom, my lords.
We submit.
We submit that in the instant case, they have purchased goods intended for the cooling chambers and rooms in which we store the raw materials required for production. Without these goods, we would not be able to store the raw materials, and consequently, these goods are to be considered essential for manufacturing operations.
But what is that you manufacture?
Pharmaceutical products, my lords.
For you
Medicine-
show some literature, some standard book which say the items which you have enlisted here are required for producing those.
I'll do that. Precisely. I'll do that. Well, I'll do that, man. Kindly, I'd invite lordship's attention.
The goods which you have mentioned should be your products, things which you will put into the structure for erection of the plant. They are not covered.
My lords, if I may, my lords, there is a coordinate bench ruling of this honorable court, my lords, which has gone to the actual effect of what is 8.3b, what is Rule 15, what is the meaning of the term intended to be used in the course of manufacture, etc., my lords. And they have said that anything that comes even before or after the process of manufacture can also be covered, my lords. My lords may have that as part of my compilation if my lords.
Means those things, bricks and other things which you will put for erecting the structure.
Precisely, my lords.
Even they are covered.
Precisely, my lords. My lords may have
How?
page number, in this compilation that I've given, my lords, page number 16, my lords.
Give some time to us. We'll read that judgment and come back.
My lords.
One submission, your lordships.
Ah.
Now, what has happened is, your lordship,
Because whether manufacturing process is defined here in any of this act.
No, my lord, it will carry the excise definition of the term manufacturing. my
Ah.
lords.
Then-
Creation
Then
of a
that
new.
judgment of the apex courts goes against us. There is one judgment which Soli Sorabji had argued. In that, they have said the products means the products which are put as capital for producing for manufacturing the goods in your furnace. There, they had taken certain goods, they used it for erection of the structure, plant and machinery. The apex court said they are not produced at all. There is such a judgment. I may not be able to immediately name it. I will be able to, perhaps, but there is such a judgment. Justice Mr. Soli Sorabji had argued that matter came from Calcutta.
My lord,
There is such a judgment.
My lords, what has happened is in the coordinate bench decision, my lords, of this honorable court,
Yes.
they have referred to two other decisions of the apex court, my lords, where they have gone to the nature of expediency, my lords. What is the nature of commercial expediency? What is the meaning of commercial expediency?
Why those terms
They've
are not,
imported that into this, my lords. That
into
is why I
this,
want to point that out to my lords.
which is that judgment?
My lords, page number 16, my lords,
1/6.
1/6, my lords. 17 onwards, exact same scenario, my lords. It came up from a revision, my lords. My lords may have para 2 at the bottom on page number 17. Left side bottom, my lord. Para 2, left side bottom.
Yeah. On an inspection.
Made by the officers of the enforcement, a report came to be forwarded that C forms issued to the dealers for the purchase of goods at concessional rate from outside the state for using the same in mining of ore and manufacturing of cement has been utilized for the purpose other than mining or manufacturing activity, and dealers had purchased the goods which are neither used in the manufacture of new goods or as packing materials used in mining activity, and thereby they have violated the provision of section 10B read with section 10A.
Where is the discussion?
My lords may have page number 23 onwards, my lords.
one submission, my lords. 8(3)B treats goods used in the manufacture or processing of goods for sale on one hand, then it goes to telecommunications network, and then it says or in mining. Mining is a
This is a case that related to mining is a
My-
separate
I-
entity.
I agree. It relates to a case of mining, my lords.
That mining ನಲ್ಲಿ ಪ್ರಶ್ನೆ ಬರೋದಿಲ್ಲ. Mining, see, mining is a separate entity, separate process. This judgment will not come to your aid. If you admit that the goods which you have sold in respect of which form C you have given, if they are put into the plant and machinery or the building, etc., they do not enter the furnace at all.
precisely.
No, my lords, then we will demonstrate, my lords, as to how these are essential for us in the process of manufacture, my lords. We'll get you some, we'll get my
You
lords
can
some
do that
literature.
before the prescribed authority.
One second. A lorry will be essential to carry your goods. Do you mean to say lorry will be covered here? No. It should have nexus to the manufacturing process. This is what apex.
I agree. I agree.
Where is that?
I-
Now, otherwise, this interpretation with certificate which you have shown to us at page 3 and 4.
My lords,
That is amended certificate.
my lords.
This commodity these things should be used. See that. Pharma products including capital goods.
My lords.
If it were to be capital goods including pharma products, we would have understood. See, genus first, species follows.
My lords.
On this, there is a judgment of apex court. How species to be read, how genus should be viewed. Where genus, you can't read species to overturn the genus. That is the law. It should fit into, suppose if it were to be otherwise, linguistically, textually, had you put pharma products this side, right side, capital goods back side, then capital goods would have become genus. The gamut would be wider because including pharma products, but it's a reverse situation. Will not follow.
My lords may for a moment have page number 92, which is the first appellate authority's order, my lords.
92.
92, my lord. That's a discussion on how he looks at this scenario.
Respectfully, there is no discussion. And that is what the revisional authority finds.
No discussion at all.
No discussion at all. The
That
question
page
that your
92,
page
lordship
92, my
posed,
lords.
the question that your lordships posed, he should have found that the goods are inextricably linked with the manufacturing process.
That's what.
He simply goes on natural justice agila, I'm setting it aside.
92.
92, my lords.
On substance, there is no consideration.
Not at all, my lords.
I have built the implement endorsement dated.
My lords,
Para 8.
para 10, my lords, page number 92.
As per the registration details, not from the email offense and so application for registration making.
Let's have that, my lords.
Capital goods, etc., etc.
The category,
11.
the category of goods purchased by the appellant as per the reassessment order were found to be in the nature of capital goods utilized by the appellant in the business activity for the purchase of which the necessary permission was sought under code number 53 of subcategory B. The condition precedent for imposition of penalty would be recording a definite finding about the unauthorized purchase of goods not covered by certificate of registration
That's what.
by making false representation.
No, now things are over before us now. Admittedly, you have used them in construction. Construction is one thing, production is another. Construction is one thing, production is another. Because production, the commodities go to the furnace, to use it metaphorically, they go to the furnace. In your case, the items have gone to the paya haklik ಮಾಡ್ತಾರಲ್ಲ building ಕಟ್ಟುವಾಗ ಆ ರೀತಿಯಾಗಿದೆ foundation of the building. They will not be, it will not be manufacturing process. They have used the word manufacturing process in the manufacturing. Manufacturing is a jurisprudential word, not just an English word. Lot of literature on that, on manufacturing concept.
My lords, we will submit all of the literature, my lords, on what
No,
is used in the process of manufacture for especially pharmaceutical products, my
there is
lords.
nothing. Berkeley. Dismissed on the ground that the commodities enlisted in the amended registration certificate of 2009 with retrospective, assumedly with retrospective from 2005, has the genus, has the pharmaceutical products as the genus, and next another
Capital goods.
capital ಅಲ್ಲ. And you're right. And capital goods as the species. First off, the thrust of law is that the goods enlisted in the certificate, amended certificate to justify issuance of Form C have to be those which have put into production process or the products themselves. First, if the commodities are enlisted in the certificate or used for establishment of the plant and machinery, comma, that is not within the contemplation of legal regime. First, next paragraph. The decisions cited, this court been decision of Justice Arvind Kumar and Justice B.A. Patil did not relate to the matchable fact matrix in as much as it was a case relating to mining industry. First, dismissed.
Deeply oppressed.
Next. In case. ಸುಬ್ರಹ್ಮಣ್ಯ ಬಂದಿದಾರಲ್ಲ ಬನ್ನಿ ಸುಬ್ರಹ್ಮಣ್ಯ ಹಾ ಹೇಳಿ ಯಾಕೆ ಸ್ವಲ್ಪ ಕುಂತಾ ಇದೆ ಹುಷಾರಿಲ್ಲ ಏನು Yes.
The order of the tribunal annexure F dismissing my dispute has been challenged.
ಹೊರಡ್ರೆ ಯಾವ್ದಕ್ಕೆ ಕಾಯ್ತಾ ಇದ್ದಾರೆ ನೆಕ್ಸ್ಟ್ ಮ್ಯಾಟರ್
Directed not to take pursuant action ಅಂದ್ರೆ ಹೋಗ್ಬಿಟ್ಟು
ಒಂದೇ ನಿಮಿಷ ಅಲ್ಲಿ ನೋಡ್ರಿ ಅದನ್ನ ರೂಲ್ ಇಶ್ಯೂ ಮಾಡ್ತೇನೆ ನಾನು. ವಾಟ್ ಇಸ್ ದಟ್ ಎವ್ರಿಥಿಂಗ್ ವಿ ಹ್ಯಾವ್ ಮೇಡ್ ಕ್ಲಿಯರ್. ಅಲ್ಲಿ ನೋಡಿ ಹ್ಯಾವಿಂಗ್ ಹರ್ಡ್ ಕಮ issue will reissue rule. What members there are High Court judge. Embarrassing. Issue rule and interim order as sought for. Okay. Yes.
On the there are
Three matters. Correct. Embarrassing. Really, it's embarrassing. Not to precipitate, those words are there since 1872. What this judge says. Yes.
One of the
Yeah.
but this is the case where one of the petitioner, else your lordship say, the order of the award of the tribunal, it at page 62, it starts, my lord. The
62.
yes,
Ah.
the facts para 2. The petitioner contended that he joined the service of the second respondent party on 4/6/1963 as a temporary employee on the daily wages basis and served in various branches of the then Chitradurga and but continuously after amalgamation of Chitradurga Gramin Bank with the three regional banks Pragati coming into existence with effect from 12/5/2005, he became an employee of the Gramina Bank. Having put 20 years of service in all, he entitled regularized service and which was not being considered by the second party. In the circumstances of the temporary employee formed the union daily wages, so the union. The management did not respond the plea of the union to hear the grievance of the temporary employee union raised a dispute in the Hubli. On the failure of the reconciliation, dispute was referred to the tribunal pending adjudication. That was the.
Now, how regularization would fit into the definition of industrial dispute under 2? Yes, sir.
Yes.
The facts are like this, madam. On 7th, he is still working. He was working as a coolie on ad hoc basis, sir. The practice, of course, that practice is discontinued now. Whenever he used to approach, they used to, there was work, they used to provide it. Here, my lord, on 17/4/2013, he approached, there was no work. Immediately, he raised dispute. He filed application under section 2A of IDA Act before the central government industrial tribunal. Section 2A is pertaining to termination.
Dismissal, dismissal, removal, discharge simpliciter,
Yes.
or reduction in rank also.
Yes, sir. Yes, sir. He filed.
Well,
That
that is
was
not.
adjudicated. Evidence, the scope is whether there was a refusal of work or whether there was.
Amounts to retrenchment or not.
During the pendency, my lord, the union raised the dispute to empanel them in the list as coolies. So that was negotiated with the union. Ultimately, tripartite settlement under section 12(3) of ID Act was signed before the Labour Authority, agreeing to
That's
empanel them.
Facts is stated, is not incorrect facts.
You held that.
In fact, incorrect.
Come back.
Let he want to continue with the incorrect facts, I have no objection. Let him say.
I have ಕೇಳಿದ್ದಕ್ಕೆ
ಅಲ್ಲ ಕೇಳಿದ್ರು ನೀವು incorrect facts. Not the, my learned friend said.
Why did you go to the tribunal?
Because my lord, I was not allowed to work. I have been not allowed to work from the 2013.
17/4/2013.
Yes, my lord, your lordship. Yes. The 17/4/2013, I was not allowed to work. Now there was no termination. Nothing has been made. Then, my lord, I have approached the bank. They have not responded it. Then, my lord, I was went
Is
to
your representation to the bank?
my lord, I think that has been placed in the records. Then, my lord, I was went before the conciliation officer.
Allah, in representation kodi bank first item, what you have said to them, we'll look into.
Lord, I think record they have not allowed me to work, and that is the.
ಅದು ಎಲ್ಲಿದೆ ಅಂತ ನಿಮ್ ರೆಪ್ರೆಸೆಂಟೇಷನ್ ಅಲ್ಲಿ ತೋರಿಸಿ ಒಂದ್ ಕಡೆ ಎಲ್ಲ ಫಸ್ಟ್
I think,
ರೆಪ್ರೆಸೆಂಟೇಷನ್
Lord,
that one only.
representation ಕೊಟ್ಟಿಲ್ಲ.
No representation given.
I'll check it out.
He said that he has given representation. When we insisted for copy of the representation, he said he is not having.
But I'm sorry, he was not allowed to work. Then he approached the conciliation officer. He has provided under section 2 of the Industrial Dispute Act. He approached the conciliation officer. Then, my lord, conciliation officer called them. It was not been disputed. Then they granted to approach the tribunal.
ಅದೆಲ್ಲಿದೆ conciliation report ಇಲ್ಲಿ
Literally.
failure report.
Yes, my lord, that's the other paper is also there. Then.
Was it part of the record?
But this was the tribunal, it has been come, and on the basis of it was they refused to take me service. Then thereafter what?
One second.
Failure report ಬರಲ್ಲ ಸ್ವಾಮಿ. Because he has approached directly before the CJIT. Initially he approached Labour Authority. He was advised to approach directly CJIT. So then he filed the application before CJIT. My lord, claim statement is there. There is no failure report.
Thereafter, my lord, thereafter what has happened? The management and the labor union, there are several employees like me has been thrown out from them. Then they went on strike. Then the reconciliation officer issued a notice. In spite of that, they have not responded it. Then they prosecuted them. Thereafter, the management, they have come before the conciliation officer. Then, my lord, that I have produced it, the annexures, that R1 may be kindly be seen.
R1.
Yes, my lord. Because the union labor.
One ನಿಮಿಷ. When he gained entry to the service, which date?
Beg your lordship.
When he got appointed?
My lord, he was appointed in the year 93. My lord, I have given a date, that exact date, your lordship, 4/6/1993.
6/1993.
Lord, I have stated the facts, your lordship, in para 1 of my writ petition. Your lordship will get it without. The para 1 my writ petition.
4/6/93.
Yes, my lord.
As messenger come sweeper.
Yes, my lord. Substaff come passenger, the messenger come sweeper on a daily wages at Kallalli branch, Chitradurga Taluk on 4/6/1993. Petitioner was been working in the messenger come sweeper since 4/6/93. Petitioner worked at the head office of Chitradurga Gramina Bank on 21/8/95 to the 12/8/2006. The petitioner has worked in various branches from time to time, 4/6/2093. Petitioner also worked some other branches of Chitradurga since 2006 to 17/4/2017. The petitioner name was sponsored by the Employment and Training.
That was in 97.
97. My name has been sponsored by the Employment Exchange.
For?
Now, for appointment on their request.
No, you were appointed on 4/6.
Earlier I was appointed, then regularized, they requested, they sent an intimation to the Employment Exchange seeking a sponsor of the employers.
ಅದೆಲ್ಲಿದೆ?
That I have produced in, well, your lordship, my name was sponsored, your lordship, and my rejoinder at Annexure G.
Rejoinder.
Rejoinder nalli, page 5, Annexure G, rejoinder nalli I have produced that. Because now they said, case before your lordship, they said I have not been sponsored at all by the Employment Exchange. Therefore, my name cannot be considered their stand in the.
ಇಲ್ಲೇ ತೋರಿಸ್ರಿ. ಎಲ್ಲಿದೆ ತೋರಿಸಿ?
Annexure G, man, I think. Your lordship, may I pass on the copy of this?
Annex G na?
G, ಅದರಲ್ಲಿ rejoinder ಅಲ್ಲಿ ಹಾಕಿದ್ದೇನೆ. I'm sorry.
Rejoinder.
Because, yes, they are disputed in.
ತೋರಿಸಿ ರಿಪೋರ್ಟ್. Rejoinder. Annexure B. Annexure G.
G, my lord. Rejoinder ನಲ್ಲಿ ಹಾಕಿದ್ದೇನೆ ನಾನು. ಅವರು ನಾನು ಎಲ್ಲ ಸ್ಪಾನ್ಸರ್ ಮಾಡಿದ್ದೀನಿ, ರೆಗ್ಯುಲೈಸ್ ಮಾಡ್ಲಿಕ್ಕೆ ಆಗಲ್ಲ ಅಂತ ರಿಪ್ಲೈ ಸ್ಟೇಟ್ಮೆಂಟ್ ಹಾಕಿದ್ರು ತಮ್ಮ ಇಲ್ಲಿ ಕೋರ್ಟ್ ಮುಂದೆ. ಆವಾಗ ನಾನು
1 second. ಏನಂತ ಹೇಳ್ತಾರೆ ಅವರು?
ಇದರಲ್ಲಿ ರಿಪ್ಲೈ ಸ್ಟೇಟ್ಮೆಂಟ್ ಅವ್ರು ಏನ್ ಹೇಳ್ತಾರೆ ಅಂದ್ರೆ, 1 minute I will read out, my lord. As per the government of India, in the page 5 our reply statement ನಲ್ಲಿ
G ಓದಿ. G ಓದಿ. Annexure G ಓದ್ತಾ ಇದಿರಲ್ಲ. ಅದು ನಿಮ್ಮ
Yes, my lord, the
sponsorship.
ಚಿತ್ರದುರ್ಗ ಅಧ್ಯಕ್ಷರು ಚಿತ್ರ ಗ್ರಾಮೀಣ ಬ್ಯಾಂಕ್ ಮುಖ್ಯ ಕಚೇರಿ ದಿನಕೂಲಿ ನೌಕರರು. ನಿಮ್ಮ ಪತ್ರ ಸಂಖ್ಯೆ 2489/97, your reference dated 16/9/97. Then, my lord, then they said the name and address. I have the first name as R.V. Mohan Reddy, son of so and so. I have been sponsored by the Employment Exchange on their request.
But you were already in employment.
Already, well, that was the daily wages they are treating. They only send intimation for seeking the permanent employee. But we are they are in upper hand. I am an ordinary sweeper. They request sponsor for. Working from 93, then 97 onwards also. Yeah, then today 31 years I have been working.
ಎಷ್ಟು ವರ್ಷ ವರ್ಕ್ ಮಾಡ್ತಾ ಇದ್ದಾರೆ?
kindly.
ಇಷ್ಟೇ ಉತ್ತರ ಕೊಡ್ರಿ. ಯಾವ ಇಯರ್ ನಿಂದ ಯಾವ ಇಯರ್ ವರೆಗೆ ವರ್ಕ್ ಮಾಡಿದ್ದಾರೆ?
From which year to which year?
From which date to which date he worked in your institution, organization?
My lord, he is only working on fully intermittently, my lord. Your lordship, their own settlement, I am only, entire issue will be printed, statement of objection. Kindly see my statement of objection, my lord, filed in the requisition. Kindly come to page 13, in page 13.
13.
Yes, my lord. This is the settlement signed with the union during the pendency of the
Actually,
dispute.
that I will answer
Yes,
it.
sir.
Actually,
ಸ್ವಲ್ಪ-
my lord,
ಸ್ವಲ್ಪ-
ಅಲ್ಲ ಅವ್ರ ಸಾಹೇಬ್ರು ಕೇಳಿದ್ದು ಯಾವ ದಿವಸದಿಂದ ವರ್ಕ್ ಮಾಡ್ತಾ ಇದಾರೆ ಅಂತ ಹೇಳಿ.
ಬರ್ತಿದ್ದಾನೆ.
4/6/93 ಇಂದ ಡೈಲಿ ಫುಲ್ ವರ್ಕ್ ಮಾಡ್ತಾ ಇದ್ದೇನೆ. ನಾನು ರಿಜಿಸ್ಟ್ರೇಷನ್ ಡಾಕ್ಯುಮೆಂಟ್ಸ್ ಎಲ್ಲ ಬಂದಿದೆ, ಅದೇ ಟ್ರಯಲ್ ಕೋರ್ಟ್ ನಲ್ಲಿ ಪ್ರೊಡ್ಯೂಸ್ ಮಾಡಿದ್ದು, ಅದು ತರಿಸಿ ರೆಕಾರ್ಡ್ ಇದೆ ಇದರಲ್ಲಿ ಬಿಫೋರ್ ಯುವರ್ ಲಾರ್ಡ್ಶಿಪ್ಸ್.
Your lordship may kindly see, this is the tripartite settlement signed with them. Kindly see terms of settlement, class 1.
ಅವನ ಹೆಸರಿದೆ R.V. ಮೋಹನ ರೆಡ್ಡಿ ಇದೆ ಅಲ್ಲ?
ಇಲ್ಲೇ ನೋಡಿ.
ಹಾ.
The management agreed to enroll the services of the following workmen earlier called as coolies. He was working as coolie
Earlier,
earlier, yes.
correct.
It is not disputed. My learned friend says he was appointed as a sub-staff. That is factually incorrect.
ಇಲ್ಲ ಸ್ವೀಪರ್ ಅಂತಾನೆ ಹೇಳ್ಯಾರ.
Branches officers mentioned against their names and they are to report for their work on or before 25/11/2016.
16.
Next, my lord, I will take your lordship to para 6. Para 6.
Both parties.
Both parties, that is the union and the management.
Yes.
Both parties and the workmen agreed to continue the following cases pending as under CR 22/2003. This is relevant. General Secretary versus PGB, Daily Wage Workers Union versus PKGB, regularization of 211 workers. This is also
ಇಲ್ಲ
included.
ಅದಲ್ಲ ಸರ್ ನಾ ಹೇಳ್ತೇನೆ ಇದು ಏನಂತೇಳಿ ಅವ್ನ್ ಹಾಕಿದ್ ಕೇಸ್ ಹಾಕಿದಲ್ಲ ಮ್ಯಾನೇಜ್ಮೆಂಟ್ ನವರು ಮತ್ತೆ ಈ ಯೂನಿಯನ್ ಅವರು several employees like me have been thrown out. Then they have gone to the conciliation officer. Proceedings dispute ಅಲ್ಲ ಇದು ಕನ್ಸಿಲೇಷನ್ ಆಫೀಸರ್ ಹತ್ರ ಅವ್ರು ಸೆಟಲ್ಮೆಂಟ್ ಮಾಡಿ ಇವ್ರನ್ನ ಕೆಲಸ ತಗೊಳ್ತೇವೆ ಅಂತ.
ಅಲ್ಲ ID 6/2014 RV Mohana Reddy.
Yes, my lord. He was working as a coolie. His grievance was that he has been refused from 17/4/2013. 13. For that he has raised the dispute, not for regularization. The award is pertaining to whether there was refusal or not for regularization. My learned friend has challenged the award of the CJIT.
That's all right. But there is retrenchment. Retrenchment 210 days ಮಾಡ್ಯಾನ ವರ್ಕ್ every year.
ಅದಕ್ಕೆ ಆನ್ಸರ್ ಮಾಡಿದ್ದಾರೆ CJIT ಇಲ್ಲಿ ಅವಾರ್ಡ್. ಐ ವಿಲ್ ಟೇಕ್ ಯುವರ್ ಲಾರ್ಡ್ಶಿಪ್. ಇದೊಂದು ಓದ್ಬಿಡ್ತೀನಿ ಸ್ವಾಮಿ ಇದೊಂದೇ ಒಂದು ಪೇಜ್.
ಆಯ್ತಲ್ಲ ಇದು ಓದಿ ಆಯ್ತು ಏನಿದೆ ಇದು ಇಷ್ಟೇ.
Here
you will continue those cases.
yes.
That's the arrangement. ಮತ್ತೇನು ಓದೋದು?
My lord, kindly come to the award. Award is at annexure F, page 61. Page 61. I will take your lordship to page 62. Page 62. It is a petition filed under section 2A of the Industrial Disputes Act 1947, aggrieved by the action of the second party, Pragati Gramina Bank, presently so and so, in refusing employment to him from 17/4/2013. This is the only subject matter.
Correct.
CJIT. Then my lord, finding. Your lordship may kindly come to para 5, page 66. Yes, this is the finding. It has come during the evidence that during the pendency of the present petition.
A tripartite settlement was arrived between
Tripartite
the
settlement
management,
was arrived between the management and trade union remedy so and so on 21/11/2016, whereby the second party agreed to enroll the services of workmen earlier called as coolies to the branches bar officers mentioned against their name, and they were to report to duty on or before 25/11/2016. The first party workman so and so is one among them, and this place of work is mentioned as Goda Badnad. Among other things, it was also agreed that 6 of the above workmen will continue the pending case. Thus, it is agreed that the first party will continue its present case. It has also emerged during the cross-examination of the first party workman that he is attending the work in branch from 24/11/2016. The cause of action which occasioned in filing the present petition now ceases to exist in view of Exhibit W1. Still, the first party has not given up in pursuing the matter. In his written argument, he has contended that he has produced sufficient documentary evidence to establish that he has served for more than 240 days in several years, and those documents are not disputed by the second party. They have not produced any documents in support of their case that he is not appointed against clear vacancy of messenger, did not work continuously.
ಒಂದೇ ನಿಮಿಷ ಬಿಡಿ, ನಾವು ಓದಾಯ್ತಲ್ಲ. I come after reading. His services were engaged. You can't deny because there is record. He has been working throughout. Every year 240 days.
No, that is not there. I'll submit, my lord, all these disputed facts, my lord, are now before the CJIT in CR number 2, which I have just now referred. Evidence is almost, evidence is almost completed. The matter will be set down for award shortly. All these, whether he has worked from 1993 or not, he has not produced any material except their averment. I have disputed that.
He is not working at all.
He is now working.
Now working in your.
He is now working. From 24/11/2016 again, he is working pursuant to the settlement.
So your question, your answer is, he is working since 2016 at least,
Yes.
correct? 2016 to 2000, earlier, how many years he was working? Earlier also you admitted.
My lord, that was only, he has also accepted that he worked as a coolie, my lord.
All right.
Coolie. Coolie, the only coolie charges will be paid by the branches, my lord.
Not coolie.
By the
He has
branches.
worked, not coolie,
Coolie charges.
Messenger.
messenger.
Messenger, alla, coolie.
Messenger.
The settlement itself it is
Not the
indicated.
Substaff,
Well,
come messenger and
There is a
sweeper.
clear admission, not messenger, I am sorry. Your lordship may kindly come to his own evidence, my lord.
Employment exchange of the letter brief. Read employment exchange. They are called as
My lord,
police.
My lord, I make only one request, my lord. Kindly turn to page 29, my lord, his own admission in revision, my lord.
29.
Page 29, my lord. Cross-examination.
Ah.
Cross-examination, last sentence in the first paragraph. It is true, I was taken as coolie. There is a clear admission, even in the settlement also, it is agreed that he is working as coolie. He will be paid only coolie charges, but now I am told, my lord.
But
he
I
is
think he
being
has
paid-
not read the
being
full,
paid
he
work
only
of-
one sentence he tried to read other without them.
There is a clear admission, he
Yes,
was
sir.
not working as messenger.
It is incorrect to suggest that I was assigned well like cleaning.
Our admission is.
It is incorrect to suggest I was not been assigned to work and regulate and it is incorrect to suggest I only.
Then,
It's true, I was taken as a coolie. Him admission ಇದೆಯಲ್ಲ.
ಅಲ್ಲ ಅದು ಅದರಲ್ಲಿ ಈ 2016 ನಲ್ಲಿ ಕೂಲಿ ಅಂತೇಳಿ ಹೇಳಿ ಅವ್ರು ತಗೊಂಡಿದ್ದೇವೆ ಅಂತ ಹೇಳೋದು. ದಿ 2016 ನಲ್ಲಿ ನಾಟ್ ಇದರಲ್ಲಿ ಅರ್ಲಿಯರ್ ಐ ವಾಸ್ ಅಪಾಯಿಂಟೆಡ್ ಎಸ್ ಅ ಮೆಸೆಂಜರ್.
ಎಲ್ಲಿದೆ ಅದು?
Melody, you also I have stated so in that.
You have stated so many things. Where is the record to show that he was not a coolie, but he was a messenger?
No material.
Turn a piece of paper to.
Yes, yes, my lord.
ನೀವು ಹೇಳೋದಲ್ಲ, ನೀವು ಎಲ್ಲ ಹೇಳಿರ್ತೀರಿ, ಬಟ್ ಅಲ್ಲಿ ಏನಂತ ವರ್ಕ್ ಮಾಡಿದ್ರಿ ಅನ್ನೋದು ಬೇಕಲ್ಲ. Number 1. Now, please come to
page 15, your lordship may kindly see.
page 15.
Court nalla now all documents we produced it is a part of the original document labor court. Allala page 15 ನಲ್ಲಿ
TCR ಕೊಡ್ರಿ.
ಬಂದಿದೆ ಅಲ್ಲಿ ಎಲ್ಲ ನಾನು 93ರಿಂದ ವರ್ಕ್ ಮಾಡಿದ್ದಕ್ಕೆಲ್ಲ ಡಾಕ್ಯುಮೆಂಟ್ ಪ್ರೊಡ್ಯೂಸ್ ಮಾಡಿದ್ದೇವೆ, ನಾವು ಡಿಸ್ಪ್ಯೂಟ್ ಮಾಡಲಿಲ್ಲ.
ಏನಂತ ವರ್ಕ್ ಮಾಡಿರಿ ಬೇಕಲ್ಲ
ನಾನು ಸ್ವೀಪರ್ ದಟ್ ದಿ ಮೆಸೆಂಜರ್ ಅಂಡ್
ಎಲ್ಲಿದೆ ಎಲ್ಲಿ ಎಕ್ಸೆಪ್ಟ್ ನಿಮ್ ಪಿಟಿಷನ್ ಫಸ್ಟ್ ಪ್ಯಾರಾಗ್ರಾಫ್ ನಲ್ಲಿ ಬಿಟ್ರೆ ಬೇರೆ ಎಲ್ಲಿದೆ ರೆಕಾರ್ಡ್ಸ್?
ಇಲ್ಲಿ page 15 ನಲ್ಲಿ according to the first party this affidavit he has taken that he was doing all regular messenger office attender in
admission ಕೊಟ್ಟಿರಿ ನೀವು, ಐ ಆಮ್ ವರ್ಕಿಂಗ್ ಎಸ್ ಎ ಕೂಲಿ ಅಂತ.
ಅಲ್ಲ ಅದು ಒಂದು ಸ್ಟೇ ಸೆಂಟೆನ್ಸ್ ನಾನು ಅದ್ರ ಹೇಳ್ತೇನೆ 29 ನಲ್ಲಿ ಬರದಿ ಇಲ್ಲ ದಟ್ ಇಸ್
The regularization pending is as follows. Partly award.
That is not my case. My learned friend tried to shift it. Your lordship may kindly see the annexures. It was not between me. That is the management and labor union have agreed that they on their request I was taken back to service. It is not my representative. That is how the
ಶಟ್ರೆ ಇದನ್ನ ಅಷ್ಟು ಓದ್ಕೊಳ್ರಿ. ಓದ್ಕೊಂಡು ಇದರಲ್ಲಿ ಎಲ್ಲಿ ಅವ್ರ ರೆಕಾರ್ಡ್ ನಲ್ಲಿ ನಿಮ್ಮನ್ನ ಮೆಸೆಂಜರ್ ಅಂತ ತೋರ್ಸಾರಂತ ನಾಳೆ ತೋರಿಸಿ. I'll call this matter tomorrow. ಇಲ್ಲಿ ಎಲ್ಲೂ ಕಾಣ್ತಾ ಇಲ್ಲ. On the other hand, you have admitted that you are a coolie.
That is the page 29 stray sentence he reading it. ದಟ್ ಇಸ್ ದಿ ಕೂಲಿ ಅಂತೇಳಿ ಅವರು 2016 ಮಾಡುವಾಗ ಮಾಡಿದ್ದು, ಅರ್ಲಿಯರ್ ಕೂಲಿ ಅಂತಿಲ್ಲ.
ಆಯ್ತು,
ಅದನ್ನ
ಇದನ್ನ ತೋರಿಸಿ.
ತೋರಿಸ್ತೇನೆ.
ಇದನ್ನ ತೋರಿಸಿ. ತೋರಿಸಿ. Day after. Monday.
ಟ್ಯೂಸ್ಡೇ ಆಗ್ಬೋದು, ಮಂಡೇ.
Tuesday. ಅಲ್ಲ, ಅವ್ರಿಗೆ
ಅಲ್ಲ, ಮಂಡೇ ನಾನು ಬರೋದು ಲೇಟ್ ಆಗ್ತದೆ ಸ್ವಲ್ಪ, ಬೆಳಿಗ್ಗೆ
ಮಧ್ಯಾಹ್ನ
ಬೇರೆ
ಇಟ್ಕೊಂಡು
ಕೇಸ್ ಇದೆ.
ಮಧ್ಯಾಹ್ನ ಇಟ್ಕೊಂಡು ಹೋಗ್ಬಿಡಿ.
ಅಲ್ಲ, ಐ ಓನ್ಲಿ ಕಮಿಂಗ್ ಆನ್ ದಿ ಬ್ಯಾಂಗ್ಳೂರ್ ಆನ್
Wednesday ಹಾಕೋಣ.
ವೆಡ್ನೆಸ್ಡೇ ಆಗ್ಬೋದು.
Wednesday. ಆಯ್ತು, ಒಂದು ಬೇರೆ ಡೇಟ್ ಹೇಳಿ.
Tuesday.
ಕೇಸಿಗೆ ಗೊತ್ತಾಯ್ತು ಅಂತ ನಂಗೀಗ. ಎಷ್ಟು?
ಅಲ್ಲಿ
30th ಬೇಕಾ? ಏನ್ರಿ ನಿಮ್ ತೊಂದ್ರೆ ಇದೆಯಾ?
ಆಗ್ಬೋದು ತಾವೆಲ್ಲಿದೆ.
ಅಲ್ಲ ಹೇಳಿ, ಬೇರೆ ಏನ್ರ ಇದ್ರೆ ಹೇಳಿ, ಏನು ಯಾವ ಡೇಟ್?
ಅಲ್ಲ, ನಮ್ಗೆ 27 ನಾನು ಬರುವಾಗ ಲೇಟ್ ಆಗ್ತದೆ ಅಷ್ಟೇ.
ಅದಕ್ಕೆ ಬೇಡ, ಅವತ್ತು 27, 28 ಬೇಡ, ಅವ್ರಿಗೆ 28 ತೊಂದ್ರೆ ಇದೆ. 30th ಹಾಕಿ, 2 ದಿವಸ.
ಆಯ್ತಾಯ್ತು, ತಾವೆಲ್ಲಿ
ಬಟ್
2 ದಿನ
ಕಾಲ್ ಆನ್ 30th. ಇದನ್ನ ತೋರಿಸ್ಬೇಕು.
ತೋರಿಸ್ತೇನೆ.
ಮುಗಿದ ಅಷ್ಟೇ ಕೇಸ್.
OS ತೋರಿಸ್ತೇನೆ ನಾನು. ಅಲ್ಲ, ಇದು 1 ಮಿನಿಟ್ ಅಲ್ಲ, ನಾನು ಆನ್ಸರ್ ಒಂದೇ ಸೆಕೆಂಡ್. ಎಂಪ್ಲಾಯ್ಮೆಂಟ್ ಎಕ್ಸ್ಚೇಂಜ್ ನಲ್ಲಿ ಅವ್ರು ಕಳಿಸಿದ್ದಾರೆ, ನಾನು ಸ್ಪಾನ್ಸರ್ ಆಗಿದೆ, ನಾನು ಕೂಲಿ ಅಂತ ಹೇಳಿ. ದಟ್ ಯುವರ್ ಲಾರ್ಡ್ಶಿಪ್ ವಿಲ್ ಡಿಸೈಡೆಡ್ ದಟ್ ಇನ್ ಇಶ್ಯೂ. ನಾನು 97 ನಲ್ಲಿ ನಾನು ಸ್ಪಾನ್ಸರ್ ಮಾಡಿದ್ದಾರೆ. ನಾನು ವರ್ಕ್ ಮಾಡ್ತಾ ಇರುವಾಗ
ಏನಂತ ತಗೋಬೇಕು ಅಂತ ಸ್ಪಾನ್ಸರ್ ಮಾಡ್ಯಾರೆ.
ಅವರು ರೆಗ್ಯುಲರ್ ಅಪಾಯಿಂಟ್ಮೆಂಟ್ ಗೆ ಸ್ಪಾನ್ಸರ್ ಮಾಡಿ ಕಳಿಸಿ ಕೊಟ್ಟಿದ್ದಾರೆ. ದೇ ಸೆಂಡ್ ಇಟ್ ಮೈ ನೇಮ್ ಫಾರ್ ದಿ ಡೈಲಿ ವೇಜಸ್ ಅಲ್ಲ, ಡೈಲಿ 93 ಮಾಡ್ತಾ ಇದ್ದೇನೆ ನಾನು. ಇನಿವೆ ಇಲ್ಲ,
ಇಷ್ಟು ವರ್ಷ ಮಾಡ್ಯಾನಲ್ಲ ಅವನು.
93 ಇಂದ 31 ವರ್ಷದಿಂದ ಮಾಡ್ತಾ ಇದ್ದಾನೆ.
31 ವರ್ಷ.
ಹೌದು.
ಏನು ರೆಗ್ಯುಲರೈಸೇಷನ್ ಮಾಡ್ಲಿಕ್ಕೆ ಆಗಲ್ವಾ?
ಅದು ಇದೆಯಲ್ಲ,
ಜಡ್ಜ್ಮೆಂಟ್ ಎಲ್ಲ ಇದೆ.
211 members regularization pending ಇದೆ, is also included.
ಇಲ್ಲ, ಅದು ಬೇರೆ, ಅದು ಸುಮ್ಮನೆ. ದಟ್ ಡಿಸ್ಪ್ಯೂಟ್ ಇಸ್ ಎಂಟೈರ್ಲಿ ಡಿಫರೆಂಟ್. ಇಟ್ ಇಸ್ ದ ಯೂನಿಯನ್ ರೈಸ್ಡ್ ಇಟ್. ಐ ಆಮ್ ನಾಟ್, ದಿಸ್ ಇಸ್ ಮೈ ಡಿಸ್ಪ್ಯೂಟ್.
Adjudication is almost over.
ನೀವು ಪಾರ್ಟಿ ಅದರಲ್ಲಿ
ಅಲ್ಲ, ನಾನು ಇವ್ರು ಹೇಳುದಷ್ಟೇ, ನಾನು ನನ್ನ ಹೆಸರಿಲ್ಲ ಅದ್ರಲ್ಲಿ, ಇವ್ರು ಹೇಳ್ತಾರೆ.
ಅಲ್ರಿ,
ನಾನು ತೋರಿಸ್ತೀನಿ.
ಐ ಥಿಂಕ್
ಯೂನಿಯನ್, ಯು ಆರ್ ಎ ಮೆಂಬರ್ ಆಫ್ ದಿ ಯೂನಿಯನ್.
ಅಲ್ಲ, ಇದ್ರಲ್ಲಿ ಏನಾಗಿದೆ ಅಂದ್ರೆ ಅವ್ರು ತೋರಿಸಿದ ಅಕ್ಷರ ನಾನು ಎಕ್ಸ್ಪ್ಲೇನ್ ಮಾಡ್ತೇನೆ. ದೆನ್ ಆಫ್ಟರ್ ಎಕ್ಸ್ಪ್ಲೇನೇಷನ್ ಯುವರ್ ಲಾರ್ಡ್ಶಿಪ್ ಕ್ಯಾನ್ ಅಂಡರ್ ದೆನ್ ವಿಲ್ ದಿ ವಾಟ್ ಎವರ್ ಯುವರ್ ಲಾರ್ಡ್ಶಿಪ್ ಸೇಸ್ ವಿ ಆರ್ ಬೌಂಡ್ ಬೈ ಇಟ್.
Settlement, your lordship has seen the settlement.
ನಾನು ಅದು ಹ್ಯಾಕ್ ಸೆಟಲ್ಮೆಂಟ್ ನಾನು ಹೇಳ್ತೇನೆ.
31 ವರ್ಷ ಗಟ್ಲೆ ವರ್ಕ್ ಮಾಡಿದೆ ಅವನಿಗೆ ನೀನು ಕೂಲಿಯಾಗೆ ಸಾಯಿ ಅಂತ ಹೇಳಿದ್ರೆ ಹೆಂಗ್ರಿ?
ಅದಕ್ಕೆ ಸ್ವಾಮಿ 211 members ಪೆಂಡಿಂಗ್ ಇದೆ. ಎವಿಡೆನ್ಸ್ ಆಲ್ಮೋಸ್ಟ್ ಕಂಪ್ಲೀಟ್ ಆಗಿದೆ. ಮ್ಯಾಟರ್ ವಿಲ್ ಬಿ ಪೋಸ್ಟೆಡ್ ಫಾರ್ ಅವಾರ್ಡ್. ಆಲ್ ದಿಸ್
ಯಾವಾಗಿಂದ ಪೆಂಡಿಂಗ್ ಇದೆ? ಯಾವಾಗಿಂದ ಪೆಂಡಿಂಗ್ ಇದೆ? 2016 ಇಂದ 2016 ಪೆಂಡಿಂಗ್ ಇದೆ. ಅಂದ್ರೆ ಅವರೆಲ್ಲ ಸತ್ತು ಹೋದ್ಮೇಲೆ ಆರ್ಡರ್
direction to pass the award within 3 months.
The Umadevi case is very clear. After 10 years, I am entitled to be regularized. There are a catina of the judgment also. I can, your lordship is aware if it more than that, I will place it. But Supreme Court in several cases, they said that 10 years immediate ಮಾಡಬೇಕಂತೇಳಿ ಹೇಳಿ ಆರ್ಡರ್ ಮಾಡಿದ್ದಾರೆ. Other judgment I will place it. My learned friend tried to shift it. 31 years I have to suffer. In ಬೇರೆ ಎಲ್ಲ ಪೆಂಡಿಂಗ್ ಇದೆ, ನಾನು ಸಾಯ್ಬೇಕಂತೆ. ನಾವು ಸಾಯೋವರೆಗೆ ಇವ್ರು ಕಾಯ್ತಾ ಇರ್ತಾರೆ. ನಾವು ಸಂಡೇ ನಾವು ವರ್ಕ್ ಮಾಡಿದ ದಿವಸ ಸ್ಯಾಲ್ರಿ, ಒಂದ್ ದಿವಸ ರಜೆ ಕೊಡಲ್ಲ, ರಜೆಗೆ ಸ್ಯಾಲ್ರಿ ಕೊಡಲ್ಲ, ಸಂಡೇಗೆ ಸ್ಯಾಲ್ರಿ ಇಲ್ಲ. ಇಂಡಿಪೆಂಡೆಂಟ್ ಡೇ, ರಿಪಬ್ಲಿಕ್ ಡೇ ರಜೆ ಕೊಡ್ತಾರೆ, ಸ್ಯಾಲ್ರಿ ಕೊಡಲ್ಲ. I have been working 31 years. ಒಂದೊಂದು ದಿವಸಕ್ಕೆ ಮಾತ್ರ ಸ್ಯಾಲ್ರಿ.
My lord,
and no leave will be granted. And if I applied a leave, I will not no salary, because the catina of the judgment of the Supreme Court says catina of the judgment of the Supreme.
My lord came down heavily for not posting presiding officer for CJT. Now presiding officer is there. Your lordship may give direction to complete that within 3 months.
ನಮ್ ಕೇಸಿಗೂ ನಮ್ ಕೇಸಲ್ಲಿ ಡಿಸ್ಪ್ಯೂಟ್ ಮಾಡ್ಸ್ಕೊಂಡು ಬಂದಿದ್ದಾರೆ. ನಾವು ಅದಕ್ಕೆ ತಪ್ಪ ರೈಟ್ ಅಂತ ತಮ್ಮ ಮುಂದಿದೆ, ತಾವು ಡಿಸೈಡ್ ಮಾಡಿ.
ನೀವೇನ್ ಮೆಂಬರ್ ಅಲ್ಲ ಅಂತ ನೀವ್ ಅನ್ಕೊಳ್ಳೋದು?
ನಾನು ಪಾರ್ಟಿ ಅಲ್ಲ, ಅದ್ರಲ್ಲಿ ಪಾರ್ಟಿ ಅಲ್ಲ, ಬೇರೆಯವ್ರು ಹಾಕಿದ್ದಾರೆ. ಕೆಲವರು 5-6 ವರ್ಷದವರು ಇದ್ದಾರೆ, 10 ವರ್ಷದವರು ಇದ್ದಾರೆ. ನಂದು ಇಂಡಿಪೆಂಡೆಂಟ್, ನನ್ ಕೇಸ್ ಡಿಸ್ಮಿಸ್ ಮಾಡಿದ್ರ ಮೇಲೆ ನಿನ್ನ ಟ್ರಿಬ್ಯುನಲ್ ನಲ್ಲಿ ನನಗೆಲ್ಲ ರಿಲೀಫ್ ಕೊಡ್ತಾರೆ? ನಿಮ್ ಕೇಸ್ ಡಿಸ್ಮಿಸ್ ಆಗಿದೆ, ಹೈಕೋರ್ಟ್ ನಲ್ಲಿ ಕನ್ಫರ್ಮ್ ಆಗಿ ಹೈಕೋರ್ಟ್ ನಲ್ಲಿ ಇದೆ, ನಾವು ಕೊಡುದಿಲ್ಲ ಅಂದ್ಬಿಡ್ತಾರೆ ಅಷ್ಟೇ. ಇವ್ರು ಹೇಳ್ತಾರೆ, ಇವ್ರು ಇಲ್ಲ ಹೇಳ್ತಾರೆ, ಅಲ್ಲೋಗಿ ಹೇಳ್ತಾರೆ ಅವ್ರ ಕೇಸ್ ಡಿಸ್ಮಿಸ್ ಆಗಿದೆ, ಇದನ್ನೆಲ್ಲ ಡಿಸ್ಮಿಸ್ ಮಾಡಿ ಅಂತ ಹೇಳ್ತಾರೆ ಅಲ್ಲೋಗಿ. ಈ ಕೇಸ್ ಡಿಸ್ಮಿಸ್ ಆಗಿದೆ, ಅದಕ್ಕೆಲ್ಲ ಡಿಸ್ಮಿಸ್ ಮಾಡಿ ನೀವು ಅವ್ರಿಗೆ ಕೊಡ್ಬೇಡಿ ಅಂತೇಳಿ ಅಲ್ಲಿ ಅವ್ರ ಕಂಟೆನ್ಷನ್. ಈಗ ಅಲ್ಲೊಂದು ಹೇಳುದು, ಇಲ್ಲೊಂದು ಹೇಳುದು. ಯಾಕಂದ್ರೆ ಅವ್ರ ಹತ್ರ ಇವರು poor employee, lordship may ask him since how long working and how many days he worked and what is hours also. facts will, truth will come. He is before your lordship today.
ಆಲ್ರೆಡಿ ಎವಿಡೆನ್ಸ್ ಹಾಗೆ ಬಂದಿದೆ
Evidence is evidence ನಾನು place ಮಾಡ್ತೇನೆ.
Much appreciated. I once again tender my apology, my lord, for not being present when the case was called.
ಹೌದು. ಅದೇನಕ್ಕೆ ಇಲ್ಲ, ನಾನು ಇಮಿಡಿಯೇಟ್ ಫೋನ್ ಮಾಡಿದ್ದೇನೆ, 2 ಸಲ ಫೋನ್ ಮಾಡಿದ್ದೆ. ಇಲ್ಲ, ನಾನು ಅವ್ರಿಗೆ
30th.
ರೆಕಾರ್ಡ್ ನೋಡ್ಬೇಕಾದ್ರೆ ಎವಿಡೆನ್ಸ್ ಎಲ್ಲ ಮಾಡಿ.
ನಾಳೆ ಬೆಂಚ್ ಇದೆಯಾ? ಹೌದಾ? ಸ್ಯಾಟರ್ಡೆ ಇದೆ. ನಾಳೆ ಬಂದ್ರು ಓಕೆ, ಸ್ಯಾಟರ್ಡೆ ಇಲ್ದಿದ್ರೆ ಒಳ್ಳೇದಿತ್ತು. ಬೆಳಗ್ಗೆನೆ ಸ್ಪೋರ್ಟ್ಸ್, ಮಗಂದು ಸ್ಪೋರ್ಟ್ಸ್ ಬೆಳಗ್ಗೆ. ನಾನು ಅಲ್ಲಿ AG ಆಫೀಸ್ಗೆ ಹೋಗ್ಬೇಕು. ಇವ್ರಿಗೆ ಹೇಳೋಣ ಅಂದ್ರೆ ಪಾಪ ಇವ್ರಿಗೆ ಟ್ಯಾಕ್ಸ್ ಅಷ್ಟೇ ಆಗಿದೆ. ಒಂದು ಮ್ಯಾಟ್ರ್ ಇದ್ರು ಬರ್ಬೇಕಲ್ಲ ಅದು. ಸರ್ ಇದು 22 ಯಾವ ಡೇಟ್ ಕೊಟ್ರು ಸರ್? ಸೊ ಅದೇ ನಾವು ರೆಸ್ಪಾಂಡೆಂಟ್ ಅಂದ್ರೆ ಅವ್ರು ವಕಾಲತ್ ಹಾಕಿದ್ದಾರೆ ಸರ್. 29th ಅಲ್ಲ, ಸ್ಟೇಟ್ ಕನ್ಸ್ಯೂಮರ್ಗೆ ನಾವು ವಕಾಲತ್ ಹಾಕಿದ್ದಾರೆ ಸರ್. ಆ ಗವರ್ಮೆಂಟ್ ಇಂದ ಇದು ಬಂದಿದೆ. ಈ ಸರ್ ಇಲ್ಲ ಅಂದ್ರೆ
So that ಯಾಕಂದ್ರೆ 30th ಇದೆಯಲ್ಲ, ಅವ್ರನ್ನ ಆರ್ಗ್ಯೂ ಮಾಡಕ್ಕೆ ಬಿಡಲ್ಲ.